May I have your lordship's leave to, my lord, file an anticipatory bail, my lord? Here GR number is not there. My lord, it is not getting, my lord. There is no GR number, my lord. My lord, I have instructions, my lord, from the learned advocate of the trial court, my lord, that till date there is no GR number. My lord, that's true. That's true. I have, my lord. Ask your trial court lawyer. Very good.
Your Lordship, praying for inclusion in the list as a bail in connection with appeal.
Same, bail in connection.
One appeal hearing matter come on plain.
My lord, bail in
Not bail in connection with everything.
No, my
Bail in connection. Bail in connection with relaxation of condition. Lord, only page item number 3 in the monthly list. Lord, all I am praying Lord to be listed in the supplementary list. Of course.
Your Lordship, may I be allowed to mention one matter, Your Lordship, for upgradation. It is there, Your Lordship, in the monthly list. Item number 461, Your Lordship. The urgency is that, Your Lordship, matter pertains to, Your Lordship, that the petitioner is the unfortunate father whose son, Your Lordship, died in hostel, Your Lordship, in mysterious circumstances. Your Lordship, his allegation is that, Your Lordship, that the postmortem as well inquest was not conducted in accordance with law, Your Lordship. No, not accurate. Intercourt appeal, Your Lordship. That matter, Your Lordship, assigned before Your Lordship by the Your Lordship, assigned matter, Your Lordship. Lordship, fine. Yes.
Right.
Item 1.
Lord, I'm appearing on behalf of the de facto complainant in this matter. Lordship, I have taken out that application. If your Lordship kindly recalls, one of the appellants, upon violating the terms of the parole, yes,
By the investigation.
there was a direction to for production of the trial court records.
The 2 leads has been fined. Lord, can it be 4 weeks? Can it be 4 weeks?
Lordship, direction to prepare paper books is within 3 weeks. Deeply obliged.
Item 2.
After your lordship's order, my lord, step has been taken. Petitioner was arrested and subsequently
Granted bail.
tipped up.
Item 5, 6, 7.
Well, I'm representing 6 and 7. But at the outset, we are very grateful to your lordship because
pursuant to your lordship's direction. Sir, একটু দিয়ে দেবেন না? And this is the second copy for Malasis Khan. But kindly see para 10 onwards. ওরা সেটা কপি আছে কিনা দেখো, এখানে নেই। Then kindly see the order passed by the learned trial and see the conduct of the one of the accused person. Kindly see it below. And what is the observation passed by the learned court below? Zoom করে রাখেন। Smell it. We have, but I don't know what is in the report. Still give me.
Well, the order has not been uploaded, subject to correction by your lordship. Well, subject to correction, my lord. No,
Lordship.
no, my lord, all copies we have not got as yet. Well, the difficulty is that, my lord, the index was. Well, the, huh?
At that time, there's that issue in the course of it will be supplied immediately and with action. We are not being like the register. They are not even any of the total pages they are relying on. And they're not
And to
my lord,
whatever is supplied, it will be. And in additional, you will be inspection and ID processor.
and to avoid any controversy, tomorrow we are supplying all the scanned copy of the document.
well, that they will be supplying tomorrow, my lord. Please, my lord.
Say that as per circular also scanned copies are going to be supplied and that
Well, my lords are absolutely right, my lord. Tomorrow, when they will serve the the scan copy, my lord, it will be easier for us to tell, my lord, what is the deficiency.
Yes, it will be paginated. I just had a word. Yes. Yes.
Well, then everything will come down to an end.
Yes, my lord.
understand from their side. Instead of this proposed instead of God, instead of witnesses to do not declare facts.
Lordship.
Instead of document statements of the statement, each one statement of
So, yes.
page 1 YZW statements, they come to document ABC, whatever is here, it's legal risk and inclusive along with let them do.
As your lordship, please.
Would your lordship want to see what had happened with me? Ultimately, what your lordship, I'll just show because I'm also bound for compliance. This is what we've deposited in the lower court. Malad kindly sees, we are in a slightly different situation, Hazra. Malad sees paragraph number 3, 7, and 8. We are very grateful to CBI. They were cooperative, but there are some issues which are there, Malad. Sees paragraph number 3, paragraph number 7, and 7 and 8. So far as we were concerned, we got first day we got an inspection chance of 345 to 482. Right? But there were about being total 137 documents, Malad, where substantial documents were missing. Malad, we indicated that in Annexure P3. After that, Malad, your lordship's pleasure would be to kindly come to number 7, paragraph number 7. On the next day, Malad, we got an inspection of total 79 documents. Now, Malad, the issue is that we came to know, the representatives came to know that there are different IOs involved in this investigation. The name of our IO, so far as Shumon Hazra is concerned, his name was Ashutosh. He was dealing with us. So he said that we are going to take out, the investigating agency is going to take out piecemeal manner. That's the reason why first day that lot came out and the second day this lot came out. So we got this to see and we indicated what documents we do not have. We did not get so far as this is concerned. And paragraph number 8 is the total managed to produce 216 documents in 2 days. That's about 14 hours today. 266 is left. Now I leave it upon your lordship whether
266 is left is in.
We have been able to, out of 482, the CBI gave us 216. We indicated what we've not been able to see over there also. CBI has given us pen drive which came to us last evening. We've not been able to verify that much.
But however, we have got to see 216 documents and what is remaining. Now 266 is left out of 482.
Supposed to do
Yes.
is we follow that you have inspected, according to you, inspection is not complete, further inspection of documents are necessary. In the meantime, Mr. Mojumdar proposes
Yes.
that, and also the order of the trial judge indicates that by tomorrow, they are going to supply all the scanned copies of relied upon documents to all the accused persons, correct? Since the amount is voluminous, we are giving you 7-day time. We are keeping it on Tuesday again at 10:30 a.m. All right. In the meantime, please go through it, and we will request the trial judge to place this matter any day prior to the next hearing, subject to the convenience of the court, and get your responses on
What we are not getting.
what you have not.
Yes,
or
yes,
whatever. All right. So
Yes, Madam.
we keep it on Tuesday. The judge can keep it on Monday or on Saturday because it's a working Saturday,
Yes.
I think. So we don't want to burden the judge with a specific mandate.
Right.
We keep it loose. We will say that in the meantime, either on Saturday or Monday, as the judge's convenience, can fix it so that you can exchange the views, get an order, and again,
Perfect.
we sort of supervise the exercise. Our endeavor to do that, we have made it very clear on the last occasion, is to iron out creases, remove any perception of unfairness or hastiness in the trial process, but also not allow the excuse of the due process as a subterfuge to derail the trial.
We are sure you're right.
Right? We'll do that.
Only one.
But the other accused persons, you are for Afsar, you have no opposition, you are happy. What we propose to do for the others is they don't have any objection as such, but when the scanned copies are supplied, you will look into the scanned copy and the hard copies and make your observations before the trial judge on the next day.
My lord, just one clarification subject to what Mr. Mojumdar will say. If we have an issue, can we revert to CBI?
Definitely you can revert.
No, that is the reason your lordship is
No.
giving a date
That
before
was
the
till
trial
the time
court.
the direction was there.
Just which for the Bush's case, what the trial judge has observed, please go through it. At 2:30 a.m. in the night,
Yes, the mail was given to the
mail was
officer.
sent, and
that was sent from my BS.
no,
mails
you are a hardworking lawyer. Your office works 24/7. It is appreciated, sir.
We had a
The
timeline.
thing is that at least then next day inform the CBI officer that at 2:30 a.m. we have sent a mail.
No, after that everything got
And your
regularized so
lordship
far as
can
we were
remember,
concerned.
and your
Everything got
2:30 a.m. 41A notices. But we have never seen lawyer emails at 2:30 a.m. to the police officer.
and your
We thought
lordship
the
is
time will expire. my lord.
we were
No, your lordship
The other
last
day, your
officer
lordship, the way your
very
lordship
clear.
reflected.
We understand this is spoken on a more lighter view.
No, absolutely.
We understand your urgency, etc. Your clients are in custody. We would definitely not do anything which will protract your detention and pain. But
Most of
the trial should immediately start. Framing consideration of charge. What we propose to do is by the end of this week, this supply of document exercise.
once electronic comes, let us compare through electronics.
Let it
We'll compare through electronics.
That will suffice the purpose.
Let us compare through electronics.
Yes,
regarding-
Mr.
Regarding
A,
maintainability of this appeal, may I submit one thing, just only one.
Open রাখছি।
we are
Yes, I know
very
that.
well conscious of Ram Fauji.
No, I'm just, give me 1 minute time. Well, on 23rd of August 2024, this Honorable Court, Lana Single Judge of this Honorable Court passed an order for CBI investigation. Now, we are challenging that they moved the Honorable Division Bench
No
says,
Supreme Court.
directly then go to the Supreme Court.
They went to
Division Bench, thereafter Division Bench.
no division.
Division Bench.
No division.
He was shot for, my lord.
No, all that stories are useless.
No, right.
No, Mr. Counsel. No list was filed before the division bench. There
He was shot for, my lord, I can say.
Sir, leave was sought for is nothing. Zero.
Now, thereafter, it went to the Supreme Court.
Correct.
Now,
We are not looking into the issue of transfer of investigation. We are putting a question to you, clear and simple. If a review petition is rejected, is the appeal maintainable under clause 15 or under order 47? Tell us.
so far as they have not filed a review.
We are treating the recalling application as
That
review.
your lordship will kindly see will the review.
We are treating the recalling application as review.
I have nothing to say.
Yes, don't open that.
No, my lord, I'm not.
I
I'm
made it very clear to your junior on the last occasion. A order is passed by the single judge. The order, in our understanding, was only an observation of the bench. It had no mandatory import. What it resulted in was a avalanche of consideration without even due process being followed. This order was passed without hearing some of the accused person. In our understanding, they had a right to file for recalling.
Yes.
Correct, because the principles of natural justice not followed.
Buddhiya has cases that
Correct.
out. Yes.
Second was, the judge considered the delay primarily on the anvil of
Sanction.
grant of sanction in 2 months. We indicated to Mr. Mujumdar, the law gives 3 + 1 month to grant sanction. That is not to say that the sanctioning authority would always take 4 months. But when we test 2 months as reasonable or unreasonable, we have to test it on the anvil of statutory limitations. Now, the statutory limitation being 4 months, sanction being granted in 2 months, will that trigger a direction for extreme urgency so that the consideration of charge is advised? We would use the word advised to the trial court within 7 days. This is where the review or the recalling was necessitated. The matter was placed before the Honorable Single Bench. Honorable Single Bench rightly wrongly observed, I am being called upon to decide, reopen a closed list on the basis of subsequent events. Nobody was asking, in our understanding, subsequent events. The review could have been easily disposed of, or the recalling, by saying the observation of 7 days was merely directorial and not a mandate so as to take away vital rights of parties which are germane for a fair trial or steps leading to a fair trial. That is where the appeal lies. The appeal, Mr. Tiwari. Mr. Tiwari, the appeal, Tiwari brothers. The appeal, Trivedi is there. Trivedi is not interested. He is ED. Now the game will start, sir. The day Mr. Trivedi's client files the complaint, lock, stock and barrel, it goes to the special court.
Yes.
The entire thing will go to the special court under the PMLA Act, right?
Yes.
So we'll cross that bridge if at all we need to do in this proceeding. When this was brought to our notice, Mr. Mujumdar, your junior, pointed out to us that, see, Rampoji is there. I understand Rampoji was decided. Honorable another coordinate bench referred it to larger bench. What we told them is, now if you go into this question,
It will be
you
dragged.
are actually falling into
Yes,
the
yes.
trap of the accused persons. They will be the happiest that all of us hear learned arguments on maintainability, and they get a wonderful time going to the bail bench and saying, my lord, see, maintainability is being argued, please give me interim bail. Right.
We'll come back here only.
Article 21.
We administer law realizing ground realities. We don't interpret law in vacuum. So in our first order, you will find
Yes,
we have kept that maintainability
point
to be decided and appropriate, but we have said that immediate need is to put this proceedings on rail
Yes.
and keep these persons on a tight leash. Because first thing, what we did earlier, my brother was not there. Put the other two accused
As per
on
pro-
board because we know what is going to happen. Again, the same thing which is before Justice Ghosh would be repeated. My lord, we were not heard. So everyone come on board. Secondly, we said Saturday, Sunday also don't lose. Go to CBI office, examine and compare. Go back to the trial judge, we keep it today. So we are at this stage. That is why, Mr. Tiwari, we are saying, in our understanding, your argument on the first appeals or the appeals against the initial order, well taken. Ram Fauji may stand in the way. But tell us one thing, and we would like to hear you on this. Ram Fauji restricts clause 50, but a recalling application, be it described in whatever manner, if it partakes the character of a refuse and is refused, will the appeal lie? And Mr. This is, I know your experience in civil law, that's why I am telling you also, Mr. Trivedi, will the appeal lie under clause 15 or under order 47?
Clause 40 is there, my lord. Let us patent. Its interlocutory orders has been passed. Then, my lord, appeal will
As
have
good as
maintainability.
Himji interlocutory order determined.
Yes.
What is an interlocutory order? Any order which affects vital right of party is an interlocutory order. So our understanding, when the order, the judge may consider 7 days. Judge will consider framing of charge
consideration also
within
within 7 days
7
on the
days.
next day.
Has an impact of the consideration being done on 4th itself. Partakes the character of an order which affects vital rights of parties. There cannot be any quarrel on the proposition that it is an interlocutory order or not. It is affecting rights of parties. There we take into consideration the subsequent event. Not that the subsequent event is challenged. Subsequent event is, according to the appellants here, a consequence of the
That order.
direction.
Yes.
So that direction is understood by the trial judge as a mandate. So it is our requirement to explain whether it is a mandate or not. The Honorable Single Judge could have done it in the recalling application itself, chose not to do it on the ground that
Diffuse and disposed of.
it is subject. This is the limited scope of the appeal, Mr. Tiwari. You want us, we can decide it now, but we choose
No,
not
keep
to
it
do
pending.
it now.
Keep it, that was the submission I made before the land.
Share with us without being in some way prima facie satisfied that there is an arguable case on maintainability. We would not have passed.
Lord, I am not raising that issue.
And
at
Milord,
all.
in 4G,
I am not raising that
Milord, in
issue. at all.
4G, it is also there. Milord, if the civil right is affected, then Milord, let us patent 15 is maintainable. Milord, here, what has fallen from your lordships, audio altem partem, they were not heard. But that may be a civil right.
What we
Yes, Milord, we shall argue on this. We shall
and in
argue
our
on this.
order, we have indicated 2 or 3 things. One is Hajra not being heard. He has a right to file a recall. Secondly, judge observing 2 months is an inordinate delay in grant of sanction without adverting to a statutory time limit under the Prevention of Corruption Act is a question of review or recalling, whatever you say, a legal provision not being considered. The third was the ratio of High Court of Judicature, Allahabad, impact of paragraph 47. Although it says that in exceptional cases you can give it, but what was the exceptional aspect in this case? Delay in grant of sanction. That is what the judges considered as exceptional. In doing that, judge did not advert to the statutory
Requirement.
not requirement, the
Mandate.
statutory timeline for grant.
Mandate.
So naturally, they should.
No, I understand. Milord, keep this point pending. Milord, we
My
shall
lord,
argue before
please
your lordship.
consider this, and thereafter, if you feel 7 days is good, we go back. His lordship holds, no, you are challenging the subsequent order of consideration of charge. Our understanding, subsequent order was only a consequence of
Consequential order of the.
This is where Mr. Tiwari, we felt prima facie, but we didn't want to observe it because we had not heard you. And frankly, it was the first day. It was off the cuff. Our understanding was also off the cuff. So, lest we be embarrassed by our own ignorance, we kept the issue open. we kept the issue open. But what we felt was that we should not give these people a long rope, these accused. Because if we give them a long rope, 2026 charge will not.
No doubt about that.
With the ingenuity of Mr. Banerjee and Mr. Bhattacharya et al., I am confident the charge will not be framed before 26. This I can assure.
This is being recorded, my lord.
Your lordship may say,
That is your, that's our appreciation.
I understand.
Please
Then no one got to see.
don't consider it as a judicial observation.
No, no,
It's
no.
all, as we said,
It's on a light.
on a lighter vein, and it is absolutely clear, at least from our end, and I would definitely say even the complainant will never say, far less CBI. In fact, Mr. Mojumdar also said, yes, there is quite a lot of documents. Let them compare.
Yes.
It was more in the nature of a consented order. And your junior was there, so poor girl, we didn't want to embarrass her.
And another
Said that-
new law,
No, that is another reason why we kept that maintainability open. That we will hear you. Also.
Deeply obliged for
All right, thank you.
Finally, do we compare or don't we compare with the original, which is there?
We are giving a scanned copy.
we'll see the scan copy and
Scan copy, and you can compare, and you can request CBI to supply documents. We will pass the order. Please listen to us. CBI has submitted report. In the report, paragraph 10 of the report reads as follows. Set out paragraph 10. Paragraph 10 to 12 of the report reads as follows. Full stop. The report also indicates that on 10/2/2025, the matter was heard by the learned trial judge, and the judge observed the learned counsels for Shondeep Ghosh was making baseless accusation against the agency. Furthermore, it is recorded in the order that scanned copies of the relied documents shall be supplied to all the accused by tomorrow, that is 12th February 2025, as per 12th February 2025. Good stuff. Learned counsel for Shondeep Kumar Ghosh, are you still a doctor, or your medical degree is
It was cancelled, but
suspended?
but this suspended, there's a writ procedure.
Cancelled, but it was challenged in
Like you cannot.
No, it's cancelled.
medicine as of-
It's cancelled. That I
We are
cannot do
not
practice.
describing you as a doctor. As Shondeep Ghosh contents number of documents, contents emails, contents that number of documents, relied upon documents had not been supplied, and there are deficiencies in the other documents too. He, however, he denies that he has made false, wild allegation against the agency as recorded in the order. Learned counsel, senior counsel for Kumon Hajra places on record the application placed before the trial court and submits his client had participated in the inspection and had inspected 216 out of
482.
482 documents, 482 relied upon documents. Full stop. He contends he would be in a better position to make submission after perusing the scanned documents proposed to be supplied by CBI. Learned counsels for other accused respondents also contend, while contending that documents have been supplied to them, they would make submissions after verification of the scanned documents. The case pertains to allegations of corruption by the former principal of Archicor Medical College in collusion with other office bearer
and contractor
in collusion with the office bearers and contractors in respect of various activities of the hospital. The charges are very serious and are very serious in nature, and if found to be true, would disclose a nefarious nexus between the officials in the health officials at the helm of a public hospital acting in collusion with
Kindly, my lord. All these things.
to be true.
My lord, that's not the point. These observations, as of this particular moment, for this, no, just a minute. For this exercise is not required, my lord. This is exactly what should be.
Allegations are very serious, and in order to ensure allegations are very serious, and we are informed the respondents are in jail.
Yes. Yes, deeply.
Corruption is corruption in public administration erodes the confidence of the general people in the affairs of the state. It has far-reaching consequences, polluting the clear polluting polluting the health system, it has far-reaching consequences. In the present case, it has far-reaching consequences. Polluting the.
I think your lordships are keeping these appeals alive.
We are
Perfect.
We are alive.
So
We are
now
keeping
it's
a-
207, my lord.
These observations for a pertinent reason. Corruption in high places have serious impact on public confidence in the affairs of the state. To instill affairs of the state, a prompt trial of persons accused of corruption would reinforce the faith of the people in the justice delivery system. Similarly, the accused who are in custody have a right to fair and prompt trial. The requirement of given this situation, the requirement of a prompt trial is a sine qua non in the present case, is a sine qua non, is an unexceptionable necessity for administration of justice. Full stop. With this to achieve this end, this court had passed directions for this court directed the CBI to and the accused to compare documents even during a weekend and ensure that the requirements under section 230 BNSS is complied with. Report placed before us, CBI's report indicates that such exercise had been undertaken in a has been undertaken in a substantial measure. CBI has in terms of, I think, 193 BNSS, the copies are to be supplied on in
230.
230 is
online. The facts
230 is proviso.
proviso says, na?
Yes,
The
230.
proviso
Electronic means.
Electronic means.
proviso to,
And inspection is also there.
such in compliance with proviso to section 230 BNSS, CBI has also undertaken to supply electronic copies, electronic/scanned copies to the accused by tomorrow. Respondent accused are directed to examine the hard copies as well as the scanned copy. CBI is we are conscious that the copies supplied run to over 1,000 pages. To facilitate verification and comparison, CBI to facilitate the process, CBI is directed to supply a list to supply a list of witnesses, supply an index consisting of list of witnesses, list of documents relied upon, list of witnesses, list of documents relied on documents, and paginate the scanned copies.
Now, so far as only document is concerned, I'm telling your lordship, suppose document A is a register. If that register contains 2,000 pages, we are only annexing the document A is register, pagination is so and so, not the entire document.
The document, how many pages?
Yes, that will write.
That must be.
That will indicate. That will.
That must be given.
That will indicate.
That the index comprises of 2,000 pages.
Yes.
Now, what you can do is you can paginate that index from 2001 to 2999. You can give numbers to those pages.
Yes, my lord, we shall give D1. Suppose it is a register containing 2,000 pages. We shall write that.
Describe that.
Yes.
That way. List of documents and duly paginate the relied upon documents. In the event the document is a voluminous register, etc.
Stock book, register, all of these.
Voluminous register, etc. The number of pages of the said register may be
indicated.
Supplied, may be indicated. Stop. Respondent accused are directed to verify, are at liberty to verify the documents and communicate to CBI, verify the documents and request CBI to supply, verify the documents and submit report before the trial judge.
Very well.
The trial judge is requested to fix, trial judge may fix a date subject to the court's convenience before the hearing of the matter, preferably before the hearing of the matter.
Tomorrow is the date.
Then a hearing.
Before the hearing of this court.
শনিবার বা সোমবার
We are informed date has been fixed by the trial judge on 12th. He shall be at liberty to fix another date to consider the issue, to consider the submissions of the parties in respect of the scanned documents supplied and pass appropriate order. List the this said date may be preferably fixed prior to the hearing of this case. Next hearing of the case, place the matter for hearing on Tuesday. On Tuesday.
তোমার টিউসডে অসুবিধা আছে? Sure.
Tuesday.
Only one thing, Manoj. But whatever we gathered when we read the order, the trial court said that since the matter is pending in High Court, I cannot pass an order. Now we going to the trial court gives trial court the liberty to pass necessary orders in the event certain documents are required.
Also given to the trial judge to, in the event the trial judge is satisfied
Just not
with regard to grievance, if any, raised.
correct.
Now, grievance, if any, raised by the accused, he may pass appropriate orders
That's all.
for supply of the for further supply, and the same shall be made forthwith.
And the observations made by this honorable court, subject to what
There is no observation.
Only, it's a request, my lord, you know,
There is no
before signing,
observation.
before signing the order, my lord, kindly reconsider the observations.
We will
But the situation is like, my lord, even if we win the war, battle, my lord, we're going to lose the war, my lord.
We have no doubt in our minds about two things. A charge of corruption requires to be cleared from the head of a public servant as quickly as possible.
Yes, madam.
No Indian or a foreigner suspected of a crime should be kept in jail without giving him an opportunity of a fair
Yes,
and
madam.
prompt trial. That is all that we have observed in our order.
Very well. Grateful, madam. Grateful.
But I have got a copy of the report given by Mr. Trivedi, but only with regard to paragraph 4 of the report, I need to take instruction from the petitioner. Just give it few days time.
Tomorrow?
Yeah, tomorrow will do.
In?
Monday.
Monday?
Monday.
Lordship, I have no, my lord, for the time being, I'm keeping the report with myself, or should I hand it over to Lordship?
You
How
can
can our
place it or you keep it yourself.
My lord, our only contention is, my lord, that basically Ministry
Give
of
the report to the state. State is the prosecuting.
we have given.
Got it.
Everybody has been served.
Mr. Sood, what do you say about it?
We have given it.
All right, we keep it on Monday, we hear all of you.
Instead of Monday, correct on Tuesday.
Tuesday, all right.
Just after this.
After
I'm-
this matter, he will be there.
My lord, I'm always there.
Now we'll decide.
It's a great learning process.
We will keep this matter weekly. But so far as Fauji is concerned, a dismissal of review is not governed by Fauji.
My lord, for me, it is a great learning experience.
I'm telling you, dismissal of review, the appeal lies from the civil procedure. It does not come from the latest petition. So if you don't relate to clause 15,
Lordship.
then the bar under clause 13 does not apply. Criminal matter. Only when the appeal lies, the review is appeal before the High Court.
My lord. I'm grateful, my lord. Keep the shop near these. Stop paying.
Next.
Well done for the applicant.
Okay. Oh, instruction name also.
My lord, I craved for a my lord, leave to file a supplementary affidavit since the state my lord, produced a document showing that I my lord, surrendered before the learned court. My lord, I have annexed the my lord, this subsequent certified copy. If your lordship may kindly sees copy of the certified copy, internal page 8, my lord, running page 8, my lord, where my lord, there was an apparent mistake that my name was included, Dahlia. And my lord, it was struck off by the learned court below, my lord, and it was rectified.
But
My
we
lord,
have
I did
also
not
take instruction, this is right. Well, this is instruction is also there.
Well, I did not, my lord,
Supplementary affidavit is placed on record. Full stop. Supplementary placed on record enclosing order dated 27/9/2024. The order shows petitioner's name was incorrectly recorded as an accused who had surrendered before the trial. He said the error had since been corrected. Full stop. Learned lawyer for the state also accepts this fact. Petitioner contends he has been falsely implicated in the case. Ingredients of offense punishable under section 306 IPC are not disclosed. You're the wife.
my lord, I am the wife.
Mother lodged the complaint.
After 4 months.
Petitioner is the wife of the deceased husband. Ingredients of out of depression, the deceased husband committed
But
suicide.
out of medical ailments and as well as
Acha,
depression.
out of depression arising out of due to out of depression due to ill health, the victim was depressed and committed suicide. Ingredients of offense punishable under section 300 abatement to suicide are not disclosed. She prays for ransom tribute. Learned lawyer for the state opposed the prayer. We have considered the material and submit. Petitioner used to ill-treat the husband. We have considered the materials on record. Statements of witnesses show there was there was a matrimonial dispute between the parties, and petitioner used to ill-treat the husband. On the other hand, it is contended petitioner's husband was suffering from ailment and committed suicide due to depression. No suicide note has victim did not leave behind any suicide note implicating the petitioner. Under such circumstances, we are there is no chance of abscondence. Under such circumstances, we are inclined to grant it.
PM also hanging.
Next.
14, I am for the petitioners. My lord, 420, 406 of the Indian Penal Code, my lord. There are 4 petitioners. My lord, 420, 406, my lord.
The agent,
My lord, I am the, my lord, distributor, my lord, of the de facto complainants company.
you ate up all the commission.
No, my lord. The dispute relates to settlement of accounts. My lord,
No, my lord.
lordships. My lord, may I just indicate, kindly see the FIR at page 8, my lord. In the FIR, they,
19,000 you did not account.
my lord,
53 lakhs.
that is their allegation, my lord. My lord, the due is 11 lakhs and odd, my lord. We were, they have instituted
How much check this on?
50 lakhs. They filled up
51
50 lakhs and deposited it. They have
According
according to us, my lord, 11 lakhs, out of which 1 lakh we have paid, and we have written in our representation,
supposing to pay 10 lakhs.
willing to, my lord, we have written that in our representation to the police also.
51 lakhs.
That is
10 lakhs, he's saying 10 lakhs.
I bow down to your lordship.
1 week, give
One-
10 lakhs.
1 week.
And remainder will be decided upon
Lordship.
I bow down to your lordship, my lord.
My lord.
and then 1 week.
My lord, we'll bring a draft in the name of my.
We don't know, you talk with him.
Very well.
And
Draft never to
hand over
client
the
no.
my the client also forging draft.
No, my lord. I can deposit it with the code below, my lord. I can have it
That amount you give it to him.
draft. Very well. my
On
lord.
that basis, if you have paid part payment, that will show your intention that was not to cheat.
My lord.
Remainder will be subject matter of
My
investigation.
lord, my lord. My lord, can, my lord,
Grateful, your
can,
lordship.
my lord, can there be an interim order till for a week, my lord? Can there be an interim order for a week, my lord?
Who is arresting you?
Police. Kindly, my lord.
Police. Rabiul. Islam. They are interested in
There are,
recovery.
there are 2 women also, my lord. If your lord.
They will not be arrested. Yes. All right. Money is for the complainant, not for police officer.
10 lakhs draft, my lord, I'll bring. My lord, next Tuesday, my lord.
Right.
Obliged. Obliged.
Victim lost his, my lord, the vision, my lord, in the right eye.
We have considered the material petitioner.
The other co-explain got
confidence there is a land dispute and he has been falsely implicated. He prays for acceptable and a lawyer for the state submit. Victim lost vision in one eye. We have considered the materials on record. Statements of witnesses show petitioner participated in the assault. Victim suffered grievous injury and lost vision in one eye. In light of the nature of crime, we are in light of the nature of injury resulting in loss of eyesight, we are not inclined to grant answer.
For the petitioners, allegations of 85, 108, 3.35, Bharatiya न्याय Samhita,
But
I'm the parents-in-law, my lord.
years after marriage.
Marriage in the 2009, my lord.
2009.
My lord, the petitioner number is a mother-in-law who is a my lord 64 years, my lord, and the husband and the father-in-law is all 74 years, my lord.
Case, my lord. Another case, my lord, against them started, my lord, under section, my lord, 232. And so, they're threatening the.
Attending.
My lord, all other already granted
Outside
access.
jurisdiction.
My lord, dear my lord, aged person, my lord.
Now outside.
Specific.
Now you have to also respect that threat. So we are not keeping you in custody, but stay outside jurisdiction.
No, including husband who is in Malaysia from 2020
Petitioner
year.
ask your son to take you to Malaysia. Why you will be here? Son should take care of you. Petitioners are the parents-in-law of the victim lady. She committed suicide at the parental home or at
Parental home. my lord. Parental.
incident occurred 14 years after marriage.
2009, my lord.
25. This is 2024.
No, my lord. 16 years.
16 years
16.
after marriage. 16, no, 15 years.
15 years.
15 years.
15 years after marriage.
All
Say 15 years after marriage, they pray for anticipatory bail and a lawyer for the state submit. Petitioners and other accused are threatening witnesses. A separate case has been started under section 232 BNS against them. In reply, learned counsel submit. Her clients are on bail in the said case. We have considered the materials on record. Allegations of torture are general and omnibus. Victim wife committed suicide 15 years after marriage, and statutory presumptions under 117, 118 of DSA are not attractive. In respect of allegation of threat, of holding out threat, we note petitioners are elderly persons and have been released on bail in the same case. Accordingly, we are inclined to grant bail subject to conditions. Petitioner number 2 shall meet investigating officer once in a week.
Thank you.
Kindly leave correction of the cost title, my lord. BNSS Act, my lord, instead of BNSS and BNSS.
Correctly costed.
My lord, allegation under section 126, subsection to 115 and 76.
76 is the non-billable.
Non-billable and all are billable section. My lord, 90 years old, my lord. Petitioner is a 90 years old.
90-year-old man.
My lord.
And civil dispute. We have considered the materials on record. Civil dispute is pending between the parties. Petitioner is a non-Nigerian. Allegation of assault, credibility of the allegations have to be assessed in the light of the aforesaid circumstances, including the petitioner's age at the appropriate stage of the proceeding. Accordingly, we are inclined to yes.
2406 next month.
2406.
Part payment made, my lord.
5,000 taken, 44,000 repaid, admitted.
Consider the materials on record. It is contended. It is contended that that part payment has been made of the money advanced to the petitioner, keeping it whether the petitioner had dishonest intention at the inception of the transaction has to be assessed in the light of the aforesaid circumstance at appropriate stage of the proceeding. However, custodial interrogation for progress of investigation is not necessary, and petitioner may grant.
Only that statement, which is hearsay in nature, says that it was with an assurance of providing job, but that is not there in the complaint.
Allegation, contention, prosecution case that petitioner had taken money for giving employment appears to be an afterthought. As such, since such accusation is significantly absent in the next.
My lord, item number 99 for the petitioner, my lord. My lord, allegation under section 85, 115, 117,
110.
and 110. My lord,
Attempt to control homicide.
My lord, the victim recovered, my lord. 14 years of marriage, my lord.
What is the nature of injury?
My lord, kindly see page.
Non-injury.
My lord, but 6 stitches has been given to one Rahan Mondal, my lord.
That is
From page 22 to 25, my lord.
My lord.
23 is the main, my lord.
My lord, the main petitioner, my lord, he is in custody, my lord. I am the father-in-law, mother-in-law, and other sister-in-law, my lord.
Petitioner contends they are the in-laws of the victim lady. They have been falsely implicated. Principal accused is in custody. They pray for anticipatory bail. Learned lawyer for state submit. Victim wife, na?
Victim is the
Who was assaulted?
My lord, the
My
brother
lord,
of
victim's brother, mother,
And submit that the brother-in-law, no, medical report, cut injury.
cut injury, my lord, page 23, my lord.
Who is Rahan Mundo?
Rahan Mondal is the brother of the lady, my lord.
Brother-in-law of de facto complainant is the lady.
Lady, yes, yes.
De facto complainant's brother was assaulted brutally and suffered injuries. We have considered the materials on record. Incident arose out of a matrimonial dispute. De facto complainant is the wife of the principal accused. Her brother was assaulted and suffered injury. Principal accused husband is in custody. Petitioners are the in-laws of the de facto complainant of the de facto complainant. Allegation against them are general and omnibus. Under such circumstances, we are inclined to grant anticipatory bail. Next.
My lord, in a family quarrel between the brothers, the wife was hit by a bamboo stick and was taken to the hospital, subsequently died. And there's charge sheet submitted on 22nd 8 2024.
She has died.
Yes, ma'am.
So 103 has to be added.
Well, 30
There.
302, well, it's a case of
Huh?
302 is there, 498 and 302.
Yes.
Name of the petitioner?
Name of the petitioner is Jitu Yadav.
Jitu Yadav.
File to দিন।
দুলাল দিলে জিতু
জিতু হবে
এইটা 431টা দিন। This is the statement of the husband.
Your father, against father, main allegation.
Yes, my lord. And also
My lord, out of 4 accused, 2 are on.
page 56, that is the statement.
What happened to Arvind Jadhav?
Arvind Jadhav was arrested
On
and
bail.
subsequently 156 days he has been
We are giving bail to them.
My lord.
Petitioner submits incident occurred in the course of domestic quarrel. They are not the principal accused. Principal accused has been enlarged on regular bail. They pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. A quarrel broke out amongst family members. Father-in-law, Arvind Jadhav, victim wife, victim lady, victim housewife was assaulted on the head and died. Petitioners are the brother-in-law and mother-in-law of the said victim. Principal allegation is against her father-in-law, who is on regular bail. Keeping in mind the extent of complicity of the petitioners in the crime, we are inclined to grant.
My lord, I am for the petitioner, my lord. This is a case of 126-2
My lord,
115.
on the very same footing, my lord, one of the co-accused was rejected by your lordship.
My lord, may I
Back,
submit on that point, my lord? My lord, it has been rejected by your lordship on the ground that robbery has been occurred and bike has not been recovered. My lord, there is no sections of robberies first, and secondly, the vehicle has been recovered, my lord, from the place of occurrence as per my instruction, my lord. So, and if as per the FIR, my lord, we are not the principal accused. Kindly see, FIR number 1 is the.
We are not going to go into petitioner contents.
My lord, bike has been recovered only.
There was no robbery and
There are injury also, my lord.
and
Well, this is
no specific overt act is lodged, alleged against them. They pray for anticipatory bail. Learned lawyer for state submit co-accused prayer for PRS bail of Rakul Hussain was rejected. We have considered the materials on record. Petitioners and others accosted the victim on the street.
They are next to neighbor, my
The incident happened on the street.
Yes, my lord.
And
accosted on the street. They were physically assaulted and articles were stolen. In light of the aforesaid circumstances and as prayer for PRS bail of co-accused Rakul Hussain has been turned down, we are not inclined to grant anticipatory bail to the petitioners. Next.
Monsieur, charge sheet submitted under 306, 304B, 3 years of marriage. Husband is on bail. Petitioners are the uncle-in-laws. And victim committed suicide.
Death is suicidal, allegation of torture and demand of money.
Petitioners are the uncles-in-law of the victim lady. It is contended they have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the state submit petitioners and other in-laws subjected the victim to torture. As a result, she committed suicide. We have considered the materials on record. Petitioners are the uncles-in-law of the victim lady. No specific overt act of torture has been attributed to them. Allegations are general and omnibus. Keeping in mind the aforesaid facts, we are of the opinion custodial interrogation may not be necessary and petitioners may be granted that.
Great.
Of marriage, the dispute between the in-laws family with the wife. Other co-accused are on anticipatory bail. My
law with previous injury.
charge sheet submitted, my lord.
Huh?
Charge sheet submitted.
Page 30, grievous injury. Mother-in-law was subjected to assault by this petitioner.
We have considered the materials on record.
Charge sheet submitted, my lord.
The husband of the victim lady, he assaulted his mother-in-law, resulting in grievous injury. He has absconded for 2 years. In light of the aforesaid circumstance and the petitioner's conduct, we are not inclined to grant it. Next.
Lordship, I am the petitioner, Lordship. After 15 years of marriage, there is a matrimonial discord between the parties.
Accommodation.
CD has not yet received one.
One day. No, not today. Next. 27.
Due to, my lord, and this allegation is that due to the disputing of land, the petitioner entered in the house of the complainant brothers and subsequently he assaulted.
All right. What is the nature of assault?
Lordship, with a da was received, da was seized when the petition accused number 1 was arrested. Nature of injury, Lordship, injury report is not. Injury report is
not given elaborately. They have
General.
applied for
injury report.
injury.
Report. Prayer was made.
Did he assault?
Yes.
Yes, Lordship. Page number 27 and 28, Lordship.
You have
That is-
considered the materials on record. Petitioner had assaulted the victim with a sharp cutting weapon. She had been hospitalized.
1 day.
She had been hospitalized in view of the aforesaid fact.
Lordship,
She had
he-
been hospitalized in view of the aforesaid fact. We are of the opinion this is not a fit case to grant answer. And next.
Chalo dekhiye.
Next.
Below, I am for the petitioner. Below the allegation under section below the 498A and below 313 is there. Below the petitioner number 1 is the husband. Below there the petitioners had the wife of the petitioner had given birth to a male child below 6 years after, and thereafter below again the wife conceived. Below due to some gynecological problem, the doctors will not advise for an abortion. Below on consent the aborted. Below now below the petitioners and the de facto complainant below they are residing in a same place as an husband and wife.
They are residing together. Get a further statement of the victim.
No.
Huh?
But in the FIR, the
Sir, madam, the petitioner contends that the victim is now
victim is residing, but in the FIR, in the statements of the 161 statements, that is stated that for the scenes after the marriage, there was a demand for dowry.
Are
He
you
was
going to
driven
stand
out
in
and
the
then-
way of a reconciliation
No, no,
when the
that-
dispute arose out of a matrimonial relation? Petitioners contend that the victim lady has returned to the matrimonial home and the couple is residing as husband and wife. Further statement of the victim will be recorded before magistrate and placed before this court. Adjournment.
Statement and
Next.
85, 316, 115 and 172.
Yes, nature of injury.
Very simple, it's from homeopath doctor.
Homeopath doctor, Ashok Das.
Eight and 9 is there.
Consider the materials on record. Petitioner submits incident occurred in the course of a matrimonial domestic quarrel. He is the husband. He plays for anticipatory bail and a lawyer for the state opposes the prayer. We have considered the materials on record. Allegations of torture are general and omnibus. Medical, it is contended incident occurred in the course of a domestic quarrel. Injury is simple. Under such circumstances, we are of the opinion the custodial interrogation is not necessary. Petitioner requires to cooperate with the investigation and meet investigating officer once in a while. Next.
Any time period for surrender? Any time period? 4 weeks.
Well, I'm praying for at least 2 days accommodation. CD has not received.
Which police station?
Malda.
Which police head station?
Malda police station.
Malda. Day after tomorrow.
Much obliged.
For cheating case? Huh? For that, you will marry her to
Yes, Lordship. 30, Lordship. Sorry.
Malda.
Day
After tomorrow.
Sorry.
What sort of person you are?
Lordship. Sorry.
Going to a widow and saying that I will marry you, taking 2 lakhs and running away?
No, Lordship. No, Lordship. No, Lordship. This lady initially lost the complaint, Lordship. This lady initially lodged the complaint. Thereafter, counter case lordship. Actually, she lodged this complaint that before this case lordship. After 3 months, he lodged this complaint. Initially, the boy grown up in relation with this lady. After enjoying her, leave her. Then she lodged this complaint. Counter case lordship. The lady lodged complaint on.
What is your complaint?
Lordship, can you come to Palace?
No, earlier complaint. Where is the earlier complaint? That lady lodged saying that
Lordship, Paras.
no pleading.
Paras 6, Lordship. Paras 6, Lordship.
Para
6.
But that you are saying that you are married.
Yes, Lordship, I am married, Lordship.
Married to this.
No, this man, Lordship.
This man.
In a local mandir, Lordship, temple.
Local mandir.
Yes, Lordship.
Bring both the cases.
Lordship.
First day.
I've got this.
Have you seen? There's another case, 676.
Lordship.
Bring both the FIRs.
Lordship.
Case diary of Malda PS case number 676 of 2024, along with
898.
along with that of the present case be produced.
Lordship.
Next.
My lord, there are 3 petitioners before your lordship, 325, 307, 341. My lord,
Nature of injury.
my lord, 2 groups of, my lord, in fact, the petitioner number 1 has suffered injuries, and that will be apparent from page 8 onward. Fracture of the proximal humerus.
Both will go to jail.
My lord, and lordship C, there was a meeting between 2 groups of people, and we are the persons who were attacked. My lord,
You attack, they attack, injury.
Page 45, 83, 84. He was taken from the FIR. My lord, I can collect that he was taken initially for treatment and released that.
85,
83, 84.
83.
And his statement is at page 12.
Scalp injury. Swelling. Petitioner submit that there was a free fight.
One thing. Let them stay outside the jurisdiction. Otherwise, my lord, there will be little issues.
Petitioner submit there was free fight between parties. Petitioner number 1. You started any case? You started any case?
My lord, I have complained. My complaint is lying only as a GT. I have annexed all, my lord. They are not starting a case also.
Petitioner number 1 suffered severe injuries. Complaint lodged by the petitioners have not been acted upon. Under such circumstances, they pray for answer. Learned lawyer for this, learned APP opposes the prayer. He submits petitioners are dangerous persons. We have considered the materials on record, statements, materials on record, including injury. Injuries do not appear to be grievous or life-threatening. Injuries on the victims do not appear to be grievous or life-threatening. On the other hand, petitioner number 1 lodged, suffered injury, fracture. It is contended, complaint lodged at the behest of the petitioners have not been acted upon. Under such circumstances, we are inclined to grant Anticipatory bail subject to conditions. Meet investigating officer once in a week and further.
Obliged, my lord.
Political is
Your Lordship. But I'm for the petition. Lord, case registered under section 126(2), 115(2), 117(2), 303(2) to 51(2) of the PNS Act. Now, Lord, this petitioner happens to be a tenant in respect of a self-contained flat. But initially in the year 2018, Lord, yes, what has happened? Lord, my complaint during the pendency of a suit, Lord, they have taken possession in the flat and all my articles have been removed. When I lodge a complaint, they have made it. I have annexed all the documents. Nothing.
There is injury, Your Lordship. Please kindly see the page number 6.
6.
Right. There is a medical injury. There's a blunt trauma in the left side of the chest.
Petitioner submits he is a tenant under the de facto complainant. He was forcibly dispossessed and lodged complaint with the police. No steps were taken and he has been falsely implicated in the present case. He prays for Anticipatory bail. Learned lawyer for the state content, petitioner assaulted the de facto complainant. We have considered the materials on record. Dispute arose between a landlord and tenant, full stop. It is contended the petitioner, that is the tenant, was forcibly evicted and no steps have been taken by the police. Injury report does not disclose grievous injury. Under such circumstances, we are inclined to grant Anticipatory.
Lord, there are two petitions, my Lord. I'm good. His brother has been also involved. Petition number 2.
Petition number 1 is the tenant.
But petitioner number 2 is also.
Oh, both are tenants. Oh, petitioners are tenants.
There's only one tenant.
No,
both of them are not the tenant.
Petitioner number 1 is the tenant. But he has
only the tenant.
One is the tenant. But so far as petition number 2 is the brother, he has been.
Petition number 1.
I'm grateful. Deeply obliged.
I briefly appear on behalf of the petitioner, my lord. Lord, charge sheet has been submitted under section 498. My lord, there's a mutual divorce took place, my lord. They are living separately since 2021.
Day after tomorrow.
Why day after tomorrow?
I'm told the day after tomorrow.
All the persons are already enlarged on bail.
Posting about the one day after tomorrow.
No, tomorrow I will get in the MP.
Tomorrow you will get, he will be here. Whenever it is called, he will hand it over to us.
And day after.
No. No. Tomorrow is no rest day.
No, not a rest day. Tomorrow I will get in the evening.
Tomorrow working day.
Tomorrow in the evening I will get the CD. I am told by the legal cell tomorrow evening I will get the CD.
Day after two.
Deep two.
In this matter also case diary has not arrived, my lord. Malda Manik Chowk, my lord. It may kindly be fixed up.
Rejected.
No, let's see.
Offense, what is the offense?
126(2), 1172, 118(2), 351.
326 is there, my lord. Medical is required. Medical, yes, my lord.
Which police station?
Malam Manik Chowk, kindly malam fix day after.
We just come after 5 minutes.
Lord, I am happy for the petition. Lord, the specific role has been attributed to one Sheikh Mehraj. He has assaulted the injured with a brick on his head. He has been arrested. Now, petitioner is a lady, my lord. No specific role has been attributed to her, save and except, my lord, the instigation. Well, our complaint has been treated as a GP entry. Political dispute, my lord, can you see, my lord, my role.
Victim statement of Dr. Kutner. My lord. The victim himself is a complainant, my lord. The statement, my lord. কোথায় কি আছে? তুমি আমাকে বলতে থাকো, আমি যেটা যেটা চাইছি বলতে থাকো।
Injury?
Injury, my lord, page 3, my lord. He was taken to the, my lord, nearby rural hospital. From there, he was referred and he was admitted in the, my lord, near on a nursing home. My lord. Well, the head injury, my lord. আর এটার অরুণোদয় নার্সিং হোমটা কোথায় আছে? এইটা না, 16-17।
Petitioner submit that she is a lady. There was a quarrel and she has been falsely implicated. She is not the principal accused. She prays for ransom. And a lawyer for the state opposes the prayer. We have considered the materials on record, including statement of the victim. Victim stated Sheikh Mehraj had assaulted her on the head.
Mehraj already arrested and released on bail.
Assaulted on the head and thereafter petitioner and others assaulted with lathi on other parts of the body. Injury report shows the grievous injury is on the head. Whether petitioners shared common intention to cause grievous injury has to be assessed at the appropriate stage of the proceeding. Keeping in mind the role, the extent of complicity of the petitioner in the crime, and as she is not the principal accused, we are inclined to order. The principal accused is on. Next. Hello.
Initially, case of 326, 307, subsequently he succumbed to injury, 302 has been added. Two petitioners before you
assaulted.
Yes, my lord.
Dead, my lord.
What
is the expired one?
Nobody denies expired. Who assaulted?
Bikash Pandit.
Because he is not here, my lord.
Then
He is the prime minister.
where are the statements?
Bikash Pandit, page 44.
Page 44, lord.
Vikas Pandit.
Yes. He is not here, my lord.
Include this. This is not there. Page
44, lord. Double.
44 confession are still.
44, 59, 54, so many pages, my lord.
Any eyewitness?
Because
These all are.
is it 59, 64, 74.
My lord, page number 7, my lord, page number 7.
7. This is it.
Brother of the deceased.
Brother of the deceased, lord. Page 7, lord.
Page 7.
7.
All have said.
Oh, yeah. তারপরে আমি ঠিক দিয়ে দেবো ভালো বাকি
Consider the materials on record. Petitioners are not the principal accused. Principal accused has been arrested. Keeping in mind the extent of their complicity in the crime, we are inclined to grant ransom. Next.
My lord, for the petitioner, my lord. In 2021, the present petition has been granted anticipatory bail, and thereafter he has been engaged in this case, my lord, NDPS case, my lord. 5 kilo ganja was recovered as per allegation from the.
My lord, may I say this? My lord, these persons were throwing ganja from the bordering fence towards Bangladesh. The BSF personnel apprehended, they went, they shot fires, they went away. The present petitioner fled away. The seized ganja was handed over to the customs. Now the customs have started an NDPS case. Now this case in respect to Boshirat, it's only regarding 188, 353, 506, 34. The charge sheet is also filed under these sections. The NDPS contraband sections are not there.
My lord, can you produce this record, my lord?
My lord, now the present petitioner herein has absconded for 1 year, 1 year, 2 months.
Surrender.
Well, 5 kilo ganja, my lord.
No, ganja is not in.
Ganja is not there.
Kindly
This is obstructed. Then what happened? This was in 2019.
2019, 2021, he has been granted bail. Thereafter, 2023, this case was initiated.
Correct. This is a different incident. Petitioner submits that he was falsely implicated in a case involving narcotics in 2019. Submits in 2019 he was falsely implicated in a case involving narcotics. He has been granted pre-arrest bail. Subsequently, he has been falsely implicated in the case. In the present case, he prays for anticipatory bail. Learned lawyer for state content petitioner as criminal antecedents. He was implicated in a narcotics case earlier. In the present case, he and his associates he and his associates were involved in illegal transportation of narcotics across international border. They assaulted BSF. When BSF personnel intervened, they assaulted and ran out. We have considered they ran away. We have considered the materials on record. Petitioner has criminal antecedents. Petitioner was involved in a narcotics case, earlier. In the present case, it is alleged he was involved in transporting narcotics across international border. He had absconded. His custodial interrogation may reveal ramifications of the crime, and this is not a fit case to grant absolution. Hence, this is not a fit case to grant. Next.
39 praying for not today, my lord. Not.
I was praying for not to.
Not today.
My lord. 307 corresponding section. My lord.
Injury report. Next.
No, I'm for the petition. Well, can you make it not today?
Why?
Well, I have not received the CD. 307, sir. This 307 allegation.
Then.
Lord, I am appearing on behalf of the petitioner. Well, petitioner is a retired army personnel. He raised a voice against the misappropriation of Pradhan. I filed a writ petition, filed a contempt. Thereafter, FIR has been registered
of the Pradhan.
Pradhan, my lord. Who Pradhan, my lord? But thereafter, this complaint has been registered under section 175(3) after 4 months under section 3032, my lord. The subject matter of theft is, my lord, fish from the pond of the, my lord, complainant.
Petitioner is a former army personnel.
My lord.
He raised voice against corrupt practices in the local panchayat.
My lord.
He took out an application under Article 226 of the Constitution of India before this court. and the district magistrate was directed to inquire into the allegations of corruption. Subsequently, he has been falsely implicated in a series of cases. He faced for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record.
There is no injury report.
We have considered the materials on record. Petitioner had raised his voice against corruption in the local panchayat. He had instituted a writ proceeding and direction was given upon district magistrate to make inquiry. Thereafter, he has been implicated in a number of cases, falsely implicated in a number of cases. Allegation in the present case involves theft of fish from a pond, keeping a possibility of false implication, owing to enmity with the members of the local panchayat cannot be ruled out. Under such circumstances, we are of the opinion this is not a fit case to grant bail. Petitioner shall meet investigating officer once it has been granted further. Next.
But I am for the petitioner. But I am a doctor. My father, a senior citizen, runs a catering business. Allegation is that my father could not supply sufficient food or no food at all, be that as it may. They came to my house to recover. I have abused them. Two separate cases, one from bride side, one from groom side. My father was arrested, he is in bail. In the other case, I have been granted bail after compliance of 41.
Father took 6 lakhs. Where is your father?
My father has been in custody for more than a month. Thereafter, granted bail on this.
Who? Father was arrested.
Yes.
Arrested. Petitioner is a medical practitioner. He contends he had no role to play in the catering business of his father, the principal accused. He has been falsely implicated. He prays for answer. Principal accused has been granted regular bail. Petitioner prays for answer. Learned lawyer for the state opposed the prayer. We have considered the material on record. Petitioner's father entered into a catering contract with the de facto complainant to supply food for 550 persons on the occasion of her daughter's marriage. He failed to do so. Criminal case was registered against him and his son, that is the petitioner. Nothing is placed on record to show petitioner had any role in the aforesaid business, business activity, keeping in principal accused, that is his father, is on regular bail. Under such circumstances, we are inclined to grant suitable 10,000.
Grateful.
Well, since investigation is going on, my lord, charge sheet is not submitted. So
Charge
meet
may
the
be treated by the petitioner as and when necessary.
Great.
See, what will we do with your investment?
well, there are several banks.
What will we do?
My lord, allegation under 316(2) and 318(4). My lord, I had supposedly purchased a vehicle, second-hand vehicle from my learned friend's client, paid 1 lakh in cash at the time of purchase of vehicle. Thereafter, I have paid upwards 2.5 lakhs, my lord. He says, my lord, but the quantum is not reflected. That is the difficulty with the agreement. It says that I will now start repaying the loan.
It was a higher purchase agreement.
So he says civil has got.
It is not purchase, it is just transfer.
Higher.
Higher from the bank. Bank loan is there.
Who is the person who entered into the agreement with the bank?
This is de facto component.
That is what we are saying.
Yes.
The complainant entered into a hire purchase agreement, purchased the vehicle, let out the vehicle on hire on monthly rental. He has failed to pay the rental. That is
EMI.
Where is the vehicle?
But it is with me. My difficulty is in terms of the agreement. He was supposed to transfer me the.
Delivery of the vehicle.
Well, let me just indicate one thing. Subject to what first from your lordship.
Will be seized. until and unless you settle the account.
My lord, he is not reflecting the amount outstanding as well, my lord. In terms of the agreement, my lord, sees the agreement, he was supposed to transfer the vehicle in my name. I have paid about 3,74,000 in my lord online transactions only. 2.74 plus 1 lakhs.
Contents.
My lord, I'm ready to, my lord.
He had entered into a sale agreement. He had entered into an agreement with the de facto complainant to transfer the vehicle. He has paid a sum of rupees
2.74 plus 1 lakh. 3.74.
3.74
Well,
lakhs.
total valuation, my lord, as per the instruction.
We are not concerned.
Still.
As per according to the place for for the state and de facto complainant submit, the de facto complainant is the registered owner of the vehicle. We have considered the materials on record. De facto complainant had entered into an agreement to transfer the vehicle to the petitioner. Petitioner has paid a substantial amount against the said arrangement. In respect of the said arrangement, under such vehicle is in his possession. Under such circumstances, we are inclined to grant anticipatory bail, subject to condition. Petitioner shall not transfer the vehicle to any third party without the leave of the court.
Well, it is not be transferred. Public.
And 96 NCD was seized from the alleged.
Surrender, surrender. We have considered the materials on
He had purchased the vehicle from which the seizure was effected.
Petitioner had purchased was in had purchased the vehicle which was used for transporting illegal transportation of narcotics. In view of the aforesaid circumstance and the quantity of narcotics seized, which is above commercial quantity, we are not inclined to grant that. Next.
My lord, I am for
I am for the petitioner, my lord. The allegation under section 326 capital A, that allegation in respect of petitioner number 1, over the issue of cutting a coconut
Chemical wound. He was admitted for 10 days in.
One we are rejected.
One is Devoki.
Devuk. We reject Devuk.
He threw taking this bottle from two. 1 and 2, my lord, they are
1 and 2 reject.
2 is the wife of the petitioner number 1. Your lordship, with petitioner number 1 through. Your lordship, can you consider petitioner number?
Yeah, bottle.
Your lordship, it was.
Petitioner submit, there was prior enmity between the parties. They have been falsely implicated. They pray for anticipatory bail. We have considered the materials on record. In the course of quarrel, petitioner number 2 supplied an acid bottle which was thrown at the victim by petitioner number 1. In view of the primary role played by the said petitioners, we are not inclined to grant anticipatory bail to them. Keeping, however, petitioner number 3 and 4 did not play any role in the throwing of acid. Hence, we are inclined to grant anticipatory bail. Next.
The non-bailable section is under section 307 of the Indian Penal Code. Lordship, the incident took place over the issue of demarcation of property. De facto complainant is the brother of the petition number 1. Over the same incident, we also sustained injuries. Kindly comes to page 13 and 14, and we have also filed an FIR that is at pages 10 to 12. Civil suits are also pending.
It is contended there was a free fight over demarcation of land. Both parties suffered injuries. Injury report does not show grievous injury. Under such circumstances, we are inclined to grant it.
Grateful.
What does it? Next. 49. What is this, Mr. Public Prosecutor?
My lord, wrong communicate incorporation of the name in the Wakalatnama. Your lordship had passed an order calling for an explanation, but it was relating to a anticipatory pre-years bail application. It was placed there. Now it has been assigned to your lordship. My lord, they had put in an alias. It was inadvertently done. He is praying for an unconditional apology. The superintendent correctional home, Domnam correctional home.
All right, report is placed on record. Being satisfied, in the report it is stated that the superintendent of the correctional home had inadvertently put his signature on the had endorsed an incorrect signature. Stop. His explanation is accepted. Proceeding is dropped.
Oh, acha. My lord, agi dewa ache. Atta didi. My lord, it will be controller.
Controller of the, not superintendent. Next.
My lord, conviction under 302, my lord, life.
Admitted, issue records. Liberty to pay for suspension of notice of. Next.
My lord.
My lord, I'm for the appellant, my lord. It is the order of acquittal, my lord.
Copy of the application be served.
Yes, yes. Has been served, my lord.
Please appear.
Oh, yes, yes. I shall serve, my lord. Sorry, my lord. I shall serve the copy of the
Through public prosecutor and opposite party.
1 and 4. 1 to 4.
For 4 through registered speed post we acknowledge.
Yes.
Next. Not today.
Lordship, item 54, Lordship, it's a application by the state, Lordship. We seek leave to appeal against the order of acquittal under the NDPS Act, Lordship.
Leave is granted.
Lordship.
Puroda Devi, leave is granted to prefer appeal against Swats.
Lordship had called for the records on the previous occasion. Lordship wanted to hear on the point of 52A non-compliance, Lordship.
52A?
Non-compliance, Your Lordship. In this case, the 52A was not complied. Your Lordship was of the view that in case there is non-compliance of 52A, in that case, whether Your Lordship would grant leave or not. But their subsequent Lordship.
Subsequently,
Lordship.
Bela Trivedi's
Lordship, there are too many. I'm grateful.
Yes, next matter. Is this for default? Connection to
My lord, charge sheet has been submitted. The investigation is complete. As per the last direction, that to appear once a week.
No,
So,
necessary. Investigation is complete. Accordingly, condition of bail to meet the investigating officer
once a week.
Once a week till submission of police report no longer survives. The other condition, that is, the petitioner shall not leave the jurisdiction of the PS without obtaining prior leave from IO during investigation, is also waived. He shall appear before the court, jurisdictional court on every date of hearing. Next. Which matter is yours?
59, but I was briefed yesterday.
Over time.
Well, only next
Not
week,
this week.
if your lordship kindly permits. I think he had appeared. Now I have been incorporated.
Handed over the copies of the deposition.
Ah.
No, I can assist your lordship if your lordship so desires.
Mr. Ganguly will address us later. Let the
Exactly what had
let
fallen
misfortune befall one day. Astrologically good next week or good.
whatever had fallen from your lordship for me to ascertain, it's all in their favor. It's all in their
Charge
favor.
has not been perhaps framed under 302, but conviction under 300.
Charge was not framed.
Charge was not framed. 304 charge, but conviction under 302.
Last line bola
Let us call for the TCR. He was also asking for 3 weeks.
3
Didn't
weeks.
argue on that at all. He was on 6 acquitted accused and 4 convicted. 8, sorry, 8.
না আমি 302টা বলেছিলাম 304 এ
1 second, Miss Sinha. The TCR is here. Please go through the records. Mr. Tomorrow we keep it?
Very good.
No.
Or day after, madam? Let me go through it. Well, what I had seen so far as the others,
There is two people.
oh, two
No.
people as assailants
People
of 302.
Two people exhorted.
Yes.
We have said, is the evidence of exhortation only coming from the mouth of PW3 or PW2?
PW1.
No, PW1 is
PW1 does not speak of exhortation, at least in the judgment, the way the.
No, in the deposition I have checked. It's only, and there was some confusion because the name of PW2 Habibur Rahman matches with the name of one of the acquitted accused whose name is also Habibur Rahman. That is why there was some confusion. So far as Ataur and Latif is concerned, they are the assailants whom the eyewitnesses, injured eyewitnesses
What
have
we do
named.
is, we keep it day after tomorrow. Please go through the records. If there is this
Alteration.
vital difference that charge has not been framed as conviction, on that basis we will set aside the judgment and remand it for reconsideration and final hearing.
শীটগুলো একটু দেখতে হবে না।
Final hearing.
Final hearing with after they were on bail.
Final hearing after being released of bail.
First he wants bail, then final hearing. If at the stage of bail we allow your appeal, do you have any grievance?
No, but it
Remand
will be
with bail.
restored. It will be restored as on that date prior to the conviction. So he would be. They would.
No.
Well, they were on bail during trial.
We will not, in this situation, we are not going to keep the appeal. We will allow.
I understand. No. What I was.
Allow Mr. Ganguly.
If your lordship allows the
What
appeal.
Mr. You and Mr. Manna want, you will get.
Yes, that's what I
Because
said.
the conviction will be set aside.
And then I go back to that
It will
status.
be
So it
remanded
will be
at that stage, and again
I'll be on
after
bail.
giving you an opportunity of cross-examination of the witnesses and 313 and hearing and following section 216 CRPC. 216 CRPC is mandatory in respect of a graver offense. So on that limited ground, we will allow the appeal because the TCR is before us and dispose of the order. Vishwajit Manna with score.
না কিন্তু চারজনই বোধহয় নয় convicted.
চারজন convicted, 8 জন acquitted।
302 কি?
হ্যাঁ, acquittal হয়েছে 304 এ।
চারজনই 300.
Acquittal was under 300.
How can that be?
Yes, cannot be.
You have to again tell the judge that you cannot acquit for a lesser charge and convict for a graver charge.
Reverse. He has done so.
See.
Anyway.
And if he had framed charge under
No, he has not.
find out. No.
From the records we
See
have to.
record. Judgment and
Judgment.
evidence will not tell you that. I am sure he has framed a graver charge.
Well, because the others who were acquitted, they have been acquitted under 304.
That is what we are.
So I don't think it was only 302 was framed against only 4 at the during the trial.
See the order sheet.
We will see.
See the order sheet. That's why we are saying
Yes,
it's there. We are giving 2 days. Please examine the order sheet. If that point is there, please indicate to us. On that point, we will allow you. Yes. So 59 recorded order adjourned day after 2. Yes, Mr. Pachal.
No, this special leave. I missed the bus. Now I was on leg 53.
We allowed the bus to pass.
I was since morning. I was here.
What happened to that? Who are you?
I'm the appellant.
Who are you?
Lord, I was also is a under trial prisoner. Lord, while I was in custody, I was assaulted by 2 of the under trial prisoners while I was taken to hospital. It was ordered recorded acquittal only on the ground.
Who are you?
Appellant.
Appellate. Are you the state?
No.
Then why? Where is the special leave required? You are a victim.
I am victim.
Then give him the judgment.
Mallikarjun Kodagari.
In view of the law declared in Mallikarjun Kodagali so and so, the application is not maintainable. Certified copy be returned. Applicant is at liberty to file appeal in accordance with.
Right.
Appeal under proviso to section 415 এখন কি 15 proviso to 415 না কত? When the judgment was
Judgment was passed in the month of
24
yes.
under proviso to section 372 CRPC
Get
disposed. Yes, call it. 58, my lord, we are applying for the state, my lord. Nobody is appearing, my lord. Last date also, my lord. No one is appearing. What is the matter? My lord, 302 life, my lord. 10 witnesses are there, my lord. The paper book is there. Yes, my lord. Paper book is with us, my lord. 2012 incident. Last 12 years they are in custody, my lord. He is in custody. And this is the first time they have preferred any bail. Suspension of sentence. Allegedly 2 eyewitnesses, PW1 and PW, my lord. 4. Son and mother. DW. Mr. Sion Dev at the time of Sion Dev, at the time of no Sion Dev. And my lord Anand Farmani. Anand Farmani. Farmania. Farmania. He's far away. Yes.
এই ডাকছি তোকে ডাকছি আমাকে না
Umsuman, High Court Legal Services Committee. Who is there in High Court Legal Services?
State Legal Services Office.
Yes, state. Mr. Umsuman, who are the appellants?
My lord, appellant Dhiren Hembrom, my lord.
অংশুমান চক্রবর্তী
একজন PW1, my lord, Negi Hembrom. She is the wife of the victim.
একটাই তো
হ্যাঁ, দু চারটে 10 বছর বয়স।
PW1 PW4
PW1
See the trial court records.
my lord
পেপার
দুটো উইটনেস আছে বলে দাও দুটো উইটনেস আছে
ডাক্তারটা দেখে
নাই কথাটাই বলো নর্মাল কিছু 300 PM ডক্টর হলো PW9 PW9 PM ডক্টর PW9 149টা দেখো তাহলে 9টা 149 এই তিনটে দেখলে হসপিটালে পড়তে পারি নাকি
In cross-examination, PW2 says, one says she was 20 feet from the place of occurrence.
Yes, my lord. PW2 is a Caesar list witness, my lord.
PW1.
One.
প্রেজেন্ট কি বলছে
Yes, my lord. Sir, cross examination किया है ना? Prosecution को पूछ Horrible prosecution. Jani. At the time also, I was present only. And not only that, my lord, the IO's evidence, lordship kindly see the bloodstained weapon not sent to the FSL. Nothing is nothing. No wearing appeals. Kindly consider that. Only the evidence of PW1 and 4, my lord, age 10 years. At the time of the incident, the age of the PW4 is 10 years.
Yes,
One is
1
and 4.
Then he says only he see present.
And from FIR, my lord, she contradicted in her deposition. In FIR, she stated me and my son, but in cross-examination, it said only she.
Only she.
At the time of incident, I was present only. Page 12. That she means in relation to other passers-by. Not son. Not son. Kindly see the preceding question. When the incident took place, there was none.
One or two persons were
No one, 2 persons were present by the passport. She doesn't mean the son was not there. She means that no other third party or unknown villager was there or not. And 27 recovery is there, man. What 27 recovery? The Hasua. That's ultimate. It's an embellishment, right? Embellishment. That PW1 is denied. PW1 denies that affair thing. He says there is no rumor. Yeah, that's
My mother tried.
Mother of the appellant.
Exhibit 10. Exhibit 10.
ये राजू मेरे वीरन है वांटा से बेरोते चाहिए No independent witnesses supported the
prosecution case.
recovery.
All recovery, my lord. But my lord, can you see the doctor's evidence, postmortem report, my lord, doctor's evidence? Here, my lord, the suggestion, my lord, can you see the yes, such type of injury may be caused by, my lord, the hasua, page 29, my lord, use of said hasua.
Was the recovery proved?
My lord, pursuant to his leading statement, that leading statement has been exhibited as exhibit 10.
Leading statement is exhibited. From where it is recovered?
From a pond.
Who was present at the time of recovery?
My lord,
PW 5.
5.
PW 6. Did they support the recovery?
No, my lord, they all declared.
Then it is not his residence.
No.
It's a place accessible to all. The independent witness not supporting recovery. How do you prove the recovery?
But my lord, the PW1's evidence, my lord, she stated, my lord, at that after the incident, the accused fled away from the spot with the hasua, my lord, with in his hand. So, my lord,
that is the hasua. How will we know?
That is, my lord, that was not also sent to the FSL also, my lord, by the IO.
No, you first decide whether you support the prosecution or you support the defense.
No, my lord.
You seem to be like a tree in a wind. When the wind blows from the north, you bend towards south. When the wind blows from the south, you bend towards north. You take a decision which way you stand.
My lord, if we take the evidence of PW1 and, my lord, the section 27 recovery pursuant to the statement of the appellant.
We are talking of the 27 recovery. We'll come to 1 and 4 later on. But where is the recovery? Recovery is from an open field. The persons who were supposed to be independent witnesses say that they came and they were asked to sign on blank papers. Then how is the recovery proved?
The injuries, my lord, the injuries.
Injury is proof of recovery.
No, the weapon and the injuries, my lord.
So any caste will create this sort of injury. Nobody disputes that. So it is PW 1 and 4. Well, take them. Appellant has assailed judgment and order dated judgment and order dated (18th April 2018) and 30th May 2018, convicting the appellant for commission of offence pursuant on section 302 of the Indian Penal Code and sentencing him to suffer rigorous imprisonment for life and a fine of ₹5,000 in default to suffer imprisonment for 6 months more. Prosecution case alleged against the appellant is as follows. Nobody appears for the appellant. Mr. Chakraborty, learned counsel, empaneled with the West Bengal State Legal Services Authority, is requested to represent the appellant. Member Secretary shall regularize his appointment. Prosecution case alleged against the appellant is as follows. He submit on 25/11/2012 at 7:30 p.m. One Nagi Hebram, wife of the deceased, and was accompanying her husband, that is the deceased, along with their minor son, Vishwajit, to see the immersion procession of Jagadhatri idol. When they arrived, near Narayani Pond, appellant attacked the deceased, attacked her husband, Chotur Nebram, with a hasua and struck him on the throat and neck. Thereafter, he fled. Nagi cried out for help and local people arrived at the spot. Local people came. Before her husband could be removed to hospital, she had died. She lodged written complaint at Kalna police station, resulting in registration of Kalna PS case number 525 dated 6/2/2012 under section 302 IPC. During course of investigation, appellant was arrested. Appellant made a disclosure statement that led to the recovery of the hasua near the pond. Charge sheet was filed against him and charge was framed under section 302 IPC. He pleaded guilty and claimed to be tried. Prosecution examined 10 witnesses and exhibited a number of documents to prove its case. In conclusion of trial, the trial judge by judgment order convicted and sentenced the appellant.
Caesar witness the hostile.
Appellant Mr. Chakraborty contends the purported eyewitnesses PW1 and 4 are unreliable. PW1 came out with a different version. Now, PW1's evidence is in contradiction to her, is in contradiction to the FIR. She is silent with regard to the fact that she, along with her son, was accompanying her husband. Now, she does not state that her son was accompanying them. Her son was present at the time of occurrence. She is also silent with regard to the fact that she was accompanying her husband to see the immersion procession of Jagadhatri idol. Her presence at the place of occurrence is doubtful. She, PW4 was a 10-year-old child and recollection of the event and his presence is not corroborated by his mother, PW1. Motive of the crime has not been proved. Motive of the crime has not been proved. Recovery of the offending weapon is not supported by the independent evidence, by the independent witnesses. PW5 and PW 6, na?
Yes, 8, man.
PW 5 and
There is no 5 and 8. 5, 6, and 5 and 8. Seizure witness, 8 seizure witness. Exhibit 4 এর জন্য দুটো 5 আর 8. ওদের ব্লাড ক্যান আসে 5 and 8.
PW 6, PW 5, 6 and 8, na?
Yes, 5, 6, 8.
PW 5, 6 and 8. I have considered the evidence on record in the light of the aforesaid submission. PW 1 and 4 are the eyewitnesses. PW 1 and 4 are the wife and son, minor son of the deceased Chotur Hembra. They claim to be eyewitnesses. PW 1 deposed. He had seen the incident. He was at a distance of 20 feet and had seen the incident with torchlight. She deposed appellant had killed her husband with a heshu. She proved her she lodged written complaint which was scribed by PW.
PW 3.
She proved her signature on the written complaint. She is also a signatory to the postmortem report. She admitted there is no extramarital affair between the appellant's mother and her husband. PW4 is her son. PW4 is her son. He was a minor. He was a minor child. He was a student of class 4. He was and aged around 10 years. Trial judge examined his put questions to him, and being satisfied with regard to his competence to depose, recorded his evidence. He stated his father had gone to answer nature's call beside Narayani Pukur, beside a mango tree on Narayani Pukur. Appellate assaulted his father on the neck. His mother tried to resist the accused. Good stuff. Mr. Chakraborty has strongly has vehemently questioned the credibility of the aforesaid witnesses. He contends they are relations of the accused. Their presence at the place of occurrence is doubtful. Genesis of the incident, as narrated in the FIR, is at variance to their deposition in court. Having analyzed the evidence, I have analyzed the evidence of the eyewitnesses in light of the aforesaid submissions. mere relationship is no ground to assail, is no ground to assail the presence, is not ground to assail the credibility of an otherwise truthful eyewitness. It is common knowledge. It is absurd to presume that a relation would falsely accuse an innocent person for the murder, and thereby screen the real offender. Full stop. In respect of the submission that PW wants evidence, I am also unconvinced by the submission that PW wants evidence in court is at variance to her FIR, to the FIR. In the FIR, she stated she, along with her minor son, was accompanying her husband when to see the immersion procession of Jagadhatri idol. Would stop. When they reached the crossing of the road near two ponds, Narayani and Palgor, crossing of the road near two ponds, near Narayani and Balgor pond, appellant had attacked her husband. In court, she stated appellant had gone to urinate near a tree beside Narayani pond when the victim was assailed, when the appellant attacked him. PW4 victim had attacked him. Full stop. Absence of the failure to mention this fact, failure to mention the fact that her husband was urinating at the time when the attack took place is a minor omission which does not erode, which does not improbabilize her presence at the place of occurrence. On the contrary, in cross-examination, she states she was 20 feet away from the spot when the incident occurred and had seen the incident by torchlight. She also stated after the incident, the appellant had ran away from the spot with Heshua in hand. Her evidence is corroborated by PW6, a villager. He deposed after the incident. He deposed on the fateful night. A neighbor. He deposed on the fateful night. He saw PW1 coming home from the side of the fair, shouting that the appellant had killed her husband. Full stop. PW4 is our PW4. The minor son was also present at the spot. Now, PW4's presence at the spot is questioned on the ground. PW1 claimed she was alone. PW1 during cross-examination claimed no one else was at the spot. I am of the opinion the said statement cannot be read in isolation, but in context of the earlier question put to the witness. In the earlier question, the PW1 was called upon to state whether many people were passing along the pathway of Narayani Pukur bank pathway beside Narayani Pukur, or not. In reply, she stated when in reply she stated, though one or two persons were passing the pathway, but no one was present. But no one was present apart from herself at the time of occurrence. The absence of a third party, as per the witness version, as per the witness's version, must be understood to be the unknown passerbys and not her son. In fact, the presence of her son is clearly stated in the first information report of the said witness. Presence of her son is clearly acknowledged in the first information report, wherein PW1 stated that she, along with her minor son, was accompanying her husband to see the immersion procession. Full stop. Immersion procession. This proves the immersion procession. PW4's presence is clearly established in the factual in the aforesaid factual backdrop. PW4's presence at the spot is clearly established. Though he was a minor, he had seen the brutal attack on his father, and unequivocally stated that the appellant had attacked him with a heshua, resulting in his death. Evidence of the two eyewitnesses, the aforesaid eyewitnesses, presence of PW1 and 4 at the place of occurrence is proved beyond doubt. Their evidence is credible and finds corroboration from PW6, who saw PW1 returning from the fair, crying that her husband had been killed by Dhiren. Would stop. The pristine and unalloyed version of the mother and the child relating to the death, the pristine and unalloyed ocular version of mother and the child with regard to the brutal assault resulting in death is corroborated by the medical evidence on record. PW9 found the following injuries on the deceased. He also opined that the injuries are homicidal, following the injuries, page 28. He also opined that the injuries are homicidal in nature and may be caused by the use of hashua. It is true, may be caused by hashua. It has been argued that motive of crime has not been established. When evidence of eyewitnesses are convincing and bereft of are clear, unequivocal, and convincing, and supported by medical evidence on record, absence of motive to commit the crime would not be a ground to disbelieve prosecution case. Finally, it is argued the recovery pursuant to the disclosure statement has not been proved. I find some substance in although I find some has not been proved. Recovery uh, PW10, the investigating officer deposed. Appellant had made a disclosure statement. Appellant during interrogation had made a disclosure statement, Exhibit 10. Accordingly, he took the appellant to the pond and on his identification recovered the hasua from the side of the pond in presence of witnesses. None of the independent witnesses, namely PW 5, 6, and 8, have supported the recovery. They claimed that they stated their signature was taken on a blank paper by police. Recovery is from the side of a pond which is accessible to all. Hashua, even the Hashua had not been sent for forensic examination. Though I find force in the appellant submission with regard to the doubtful recovery. In light of the doubtful recovery, in light of the convincing ocular statements of the eyewitnesses, corroborated by the medical evidence on record, of PM doctor showing cutthroat injuries, I am of the opinion prosecution case has been proved beyond doubt. Appeal is dismissed. Record our appreciation for the able assistance rendered by Mr. Chakraborty as the Oh, am I just giving that? You to keep away. They have right there.
Who is it?
60.
My lord. My lord, this is the matter, my lord, where, my lord, the co-accused was granted bail. Your lord, this is on 52A. Your lordship will find the order at page 55 of my CRAN application.
We'll take it up next week.
My lord, any day, my lord, any day except next Tuesday, my lord.
We'll just keep it next week. Then we will.
I'm informing.
Maybe for next week we will we'll sit up to 3 p.m. We'll accommodate you.
Only on next
Mr.
Tuesday.
Please make a compilation of all the judgments on 52.
My lord, of the latest ones also, my
We
lord.
have said all the judgments, latest,
my lord,
second latest,
my lord.
third latest, we are not aware.
My lord.
What is latest will depend on the day on which you are.
My lord.
Maybe again day after tomorrow another judgment. So please place on record all the judgments. Sanjana, also do that. So that we will pass the order on 52 capital.
Next week.
Also, I am for the appellant. Also, paper book
Paper
is
book
ready,
আছে?
and I am also ready only 10 pages evidence. Also. ওই 29 নোট করে নিবে Lordship, in this case from the appellant and one Shamol Sarkar who died subsequently 52 kg 900 grams of codeine mixture liquid was found 60 liters. Now they were appellant was convicted under section 21C and sentenced for 14 years. Now Lordship, there are two independent witness PW 14 years. Lordship, 4 years 11 months. Now, Lordship, there are two independent witnesses, PW3 and PW4. Both PW3 and PW4, you Lordship will find at page 12 and 13. They state that they don't know about the content of the seizure list. Now, Lordship, there is a exhibit that is inventory that your Lordship will find at page 5 of the paper book. Now, this inventory was prepared not by the officer in charge, but by the investigating officer. The name is written there, name and designation of the officer prepared this inventory, SI Jagannath Noskar of CID West Bengal. He is the investigating officer. Now, this inventory, subject to correction, was prepared on 25th September 2020. And charge sheet was submitted in this case on 20th August 2020. After charge sheet, with the charge sheet, chemical report was submitted. So after charge sheet, this defective inventory subject to correction, because subject to correction also 52A says the inventory should be made by the officer in charge, before whom the confinement was first time produced. Thereafter, he shall make before the magistrate for certification. Now, this certification was made, the LF seizure took place in March, 4th March, and this inventory was made after charge sheet on 25th September. The material goods seized article were never produced in court. And there is no evidence that it was destroyed also. And Lordship, the Malkhana register was also not exhibited. So during during this March to September, where these goods were, that is in September. But that is in September. So from March to September, whether these goods were under the custody of must be in a particular Malkhana. Now,
My lord, so far as the independent seizure list witnesses are concerned, they have proved their signature, my lord, on the seizure list. And my lord, with regard to 52A, what my learned friend has submitted, my lord, I need to see the exhibit, my lord. I don't have the paper book. This came under the heading bail in connection with appeal. I'm only having the application.
Lordship, IO's
9/7.
IO evidence page 20. Nah, IO page 17, PW7. No.
No.
Okay.
This was done in 26th September.
ইনভেন্টরি হচ্ছে সেপ্টেম্বরে।
অবজেকশন মনে হয়
না নেই, অ্যাটলিস্ট আমি জাজমেন্টে পাইনি।
পেজ 17 তো
আর একটু
সেকেন্ড ফার্স্ট ফাইলটা না
first file টা কি?
সেভেন্থ ফেব্রুয়ারি 2023 জাজমেন্ট আগে থাকবে আগে 7th ফেব্রুয়ারি 2023
অর্ডার শিটস 1 থেকে 18 7 ফেব্রুয়ারি 2023।
হুম
এটাই তো 23 দাঁড়া।
এইটা
Today's fixed for evidence, no witness present today. Out of the
লেখাল
না না,
এই তো এখানে ডেট আছে 7th ফেব্রুয়ারি
this is exhibit
11
witness present.
7th ফেব্রুয়ারিতে
ঠিক আছে, আমি দেখছি দেখছি।
7
আগেরগুলো
দাঁড়া
দেখছি।
দাঁড়া 5 6 7 তিনটে এখানে 7th ফেব্রুয়ারি ডেট দেওয়া
6, 10, 7. 6 তারিখে
আচ্ছা তুই এই ডেটটা দেখতো
1 মিনিট, এই চার্জশিটের পর থেকে দেখি কারণ
আরে চার্জই তো হয়েছে জুলাই 22-এ তুই 21 থেকে দেখে কি করছিস
কত হয়েছে চার্জ?
জুলাই 22 11 জুলাই 22-এ চার্জ হয়েছে
11 জুলাই।
হ্যাঁ 22
11.
11 জুলাই 22-এ চার্জ হলো
হুম।
PW1
দাঁড়া।
হলো 28 অক্টোবর 22
Teaser list 1 by 1 exhibited.
দাঁড়া দাঁড়া এটা কি PW1 হলো 28 অক্টোবর PW2 হলো
29 বা 23
document signature in the seizure list 1 by 2 1 by 3 down. 9 of the notice.
ওটা 29 এটা 31st
7 and 8. Exhibit 9 series. কত বলে exhibit 9?
11.
Witness present today.
PW7 কবে হলো দেখ এইখানে দেখাচ্ছে 7th ফেব্রুয়ারি রেকর্ডে
এই ডেটটা দেখো এপ্রিলে
এই যে এখানে PW8 হলো দাঁড়া এত তাড়াতাড়ি
6/4/2023
হ্যাঁ এটা 8 হলো PW তাহলে PW7 এর আগে হবে
এখানে তো পাচ্ছি না।
2 days fixed for evidence no witness is present
এটা কি লাগতো? এক্সিবিট কত করে দিয়েছে ওটা?
এইটা কি 5 no witness is PW7 গেল কোথায়
ওটাই তো পাচ্ছি না, দাঁড়া একটা।
তার আগে দেখি 3 4 এখানে তো 8 পেয়ে গেলাম 18 3
আগে তো
4 হলো
নেই, আমি দেখলাম তো এখানে দেখো এতগুলো এক্সিবিট হয়েছে।
এটা কে এক্সামিন হলো PW ওটাই তো 5
5
মানে PW5 হলো
হ্যাঁ
Exhibit 2, 3, 4, 5.
পিডব্লিউ হয়ে হচ্ছে গেজেটেড অফিসার, পিডব্লিউ 5 হলো। এরপরে নো উইটনেস প্রেজেন্ট, পিডব্লিউ 5 এর পরে 8 কি করে চলে এলো? হ্যাঁ, 6, 7টা একই দিনে হয়েছে। 6, 7,
6/4/23 PW8 he proved
হ্যাঁ এটা
signature.
হলো ওই যে 6 এপ্রিল 23। 6 আর 7 দুটোই 7 ফেব্রুয়ারি। 7 ফেব্রুয়ারিতে এখানে নো উইটনেস প্রেজেন্ট।
ওই জন্য তো পরেরগুলো দেখছি কোথাও কিছু ভুলচুক হচ্ছে নাকি কিছু।
দেখ, অরিজিনাল এভিডেন্স করে দেখতে একই ডেট থাকবে না, সিল
দেখছি
থাকবে।
দেখবেন দাঁড়ান। 22 আর 23 ফিক্স হয়ে গেল ফর 313।
313
না PW9 হলো
9-23 দেখি। হ্যাঁ 15-9-23 PW9। 313 হলো হচ্ছে 25শে সেপ্টেম্বর। 25শে সেপ্টেম্বর 23-এ 313 হলো।
তুমি কি বলো অরিজিনাল এভিডেন্সের ডেট গুলো?
অরিজিনাল ডেটটা দাও, PW6 এর ডেটটা দেখতো। 7 ফেব্রুয়ারি 23।
7 ফেব্রুয়ারি 23।
সই এর তলায় ডেট।
এই see part 2, exhibit 11 and exhibit 12. Part 2.
Part 2 টা একটু দাও।
See exhibit 11 and exhibit 12. They are the two relevant things with regard to 52A. Chalo, taking this.
Order dated 7 February says no witness is present.
All.
Exhibit 11.
Exhibit 12
Part 2 does it.
Exhibit 10 আর exhibit 11?
এই তো 11।
এটা ডেট দেয় সই।
NDPS.
7/2/23 সিল মারা।
Order sheet no witness.
Inventory of seized items 52.9 kg approx.
Have you got exhibit 11 and exhibit 12?
Yes, yes, yes.
11, 12.
These are the. How were they were proved? How they were proved?
Well, PW7 was PW7 was examined on 7th of February 2023, but in the order dated 7th of February 23, I do not find any.
Seven to 2023.
23.
They have been executed on admission. Sure. Appeal is directed against judgment and order dated.
কোথায়? 29টা নট টু টেন ধরলে নট টু টেন। 29 ক্যান্সেলেশন ধরা আছে। হ্যাঁ নট টু টেন।
28th February 2024.
সেবাসের আগে তো রাইজনকে প্রেজেন্ট করো।
And 28th February 2024, convicting the appellant for commission of offense punishable under section 21C of NDPS Act and sentencing him to suffer rigorous imprisonment for 14 years and pay a fine of ₹1 lakh in default to undergo simple imprisonment for 1 year more for the offense punishable under section 1 year more. Prosecution case alleged against the appellant is as follows. On 3/3/2020 at 11:40 hours, SI Shomir Ghosh of Narcotics Cell, CID West Bengal PW5 received credible information that a gang of criminals of Jalangi, Murshidabad, dealing with codeine phosphate had stored huge quantity of codeine phosphate in commercial quantity, huge quantity of codeine phosphate. And was in a clandestine manner in order to sell them for wrongful gain, and that the criminals would be delivering a consignment of the said items on 4/3/2020 in the near the international border of in the border area of Korimpur PS. The matter was the prior information was diarized and diarized exhibit 2 and communicated to to the superior officer, that is Special Superintendent of Police Operations CID West Bengal, and necessary permission to work out the information was obtained. Pursuant thereto, PW5 along with ASI Sudipto Devnath, PW1, and Sipoy Imtiaz Ahmed, PW who were the rating officers?
PW 1, 2,
3,
5,
5 is the leader.
and 9.
Sudipto Devnath, PW2 Constable.
Complainant. 7 Geo.
7 IU.
7 IU.
9.
Yeah.
And ASI Shonku Das proceeded to the spot. They intercepted a silver color Omni vehicle near silver color Omni vehicle they intercepted a কি বললাম and they কি বললাম proceeded to the spot near Bakshipur Ghat. They intercepted a silver color Maruti Omni vehicle, Maruti van bearing registration mark WB 58AP 9567 coming from Domkar, Murshidabad side. The vehicle tried to escape but failed. 2 persons were found in the vehicle. The driver disclosed his identity as Shamul Sarkar and his companion was Shafiqul Islam, that is the appellant.
দিনবাদে চার্জ হয়েছে খবর 20 সালে হয়েছে না সাপ্লিমেন্টারি চার্জশিট
During COVID seizure, on search, 3 blue-colored 20-liter mineral water jar containing liquid material having smell of codeine phosphate mixture were found in the car. তার আগে prior to seizure, prior to ওই intercepted তো notice under section 50 of NDPS Act was served upon them. They wanted to be searched in presence of a gazetted officer, search upon them. Thereafter, Inspector Shondip Ganguly, OC Narcotics Cell, CID West Bengal, PW 8 was summoned to the spot. In his presence, search commenced. তারপরে ওই 3 blue-colored 20-liter mineral so-and-so was found inside the car. The said 20-liter, the said consignment was seized. Appellant and Shamul Sarkar was seized in presence of independent witnesses. Appellant and Shamul Sarkar were arrested.
Shamul Sarkar মারা গেছে
And FIR was registered against them, as well as one Rana Sheikh, Koitul Khan, and registered owner of vehicle numbers of the said vehicle being on the written complaint of PW5 and on the written FIR was registered, being Korimpur PS case number 53/20 dated 5/3/2020 under section 21C 2529 of NDPS Act. In course of investigation, the seized consignment was inventorized and duly certified by magistrate under section 52A NDPS Act. Samples sent to the chemical examiner's report. Exhibit 12 showed samples tested positive to codeine phosphate. Charge sheet was filed.
No, prior to that, charge sheet was filed.
Charge sheet was filed. Charge sheet and supplementary charge sheets were filed, enclosing the said documents. Shondip so-and-so had absconded and charge was the other accused were discharged.
He died, Manoj.
Who died?
Shamul Sarkar.
But what about the other FIR name?
The charge sheet was only against Shamul and Shafiqul.
Okay. Charge sheet and supplementary charge sheet were filed against appellant and one Shamul Sarkar. Shamu Sarkar died and charge was framed under 21C NDPS Act against the appellant. Appellant pleaded not guilty and claimed to be tried. In course of trial, prosecution examined 10 witnesses, including and exhibited a number of documents. Defense of the appellant was one of innocence and false implication. In conclusion of trial, the trial judge, by impugned judgment and order dated so and so, convicted and sentenced the appellant as aforesaid. Mr. Chatterjee contends the recovery has not been supported by the independent witnesses. Independent witnesses, they claimed they had signed on, they did not identify the appellant and claimed they signed on blank documents. He further contends the certificate, the inventory was made by police officer, made by PW9. Inventory was prepared by PW9.
PW 7.
The inventory was prepared by the investigating officer PW7 and not the officer in charge of the police station. Malkhana register had not been produced and the possibility of substitution cannot be ruled out. Accordingly, prayed for acquittal. Mr. Sengupta opposes the prayer. PW5 is the leader of the raiding party. He deposed. He had received prior information with regard to transportation of narcotics and diarized the fact. Diarized the same, being General Diary number 171 dated 4/3/2020. No. And diarized the had received prior information. He reduced the information into writing, Exhibit 2, and referred the same, and the said information was sent to a superior officer pursuant to the command certificate being command CC number 5 dated 3/3/2020. He formed a team and proceeded to the spot at 4:30 p.m. on 4/3/2020. He was informed by source at 4:30 p.m. on 4/3/2020. Maruti van bearing number so and so would come to Bokshitpur Ghat. He diarized the said fact. He went to Kolipur police station and sought police assistance. He proceeded to Bokshitpur Ghat. The team chased the team noticed the vehicle and chased it. They intercepted the vehicle and found two persons sitting inside the vehicle. They disclosed their names as Shamu Sarkar and Soiful Islam Sarkar, that is Sheikh, that is the appellant. They served notices under Section 50 NDPS Act, Exhibit 4 and 5. Gazetted officer Inspector Sandip Ganguly was requested to come to the spot. In the presence of the gazetted officer, 3 blue-colored jerrycans totaling containing liquid suspected to be codeine phosphate, weighing 53 kg, 500 gram was seized. They took samples from the jerrycan, one test sample and one control sample. Cash was seized. So and so. The entire entire consignment was seized. He proved the seizure list. He arrested the appellant and Shamol Sarkar. He lodged written complaint, Exhibit 7. He informed his superior officer about the search, seizure, and arrest through mail. He proved the electronic mail, Exhibit 8. He also proved the control sample. Exhibit 9 was?
Exhibit 9. GD entry, my lord.
GD book.
GD book.
The last line of page 14.
You have seen. He exhibited the GD entries, Exhibit 9 collectively. PW5's evidence is corroborated by the members of the raiding party, namely PW1, PW2, and PW9. PW1 proved his signature on the seizure list. Deposed, he prepared the seizure list and signed on it. PW2 PW9 also proved his signature on the seizure list. PW7 is the gazetted officer.
No, PW8.
PW8 is the gazetted officer. He deposed around 6:30 hours. He received information from his superior. He deposed at 18:45 hours. He received phone call from PW5 who requested him to come to the spot for witnessing search and seizure. At 7 he arrived at the spot. A Maruti vehicle had been bearing registration mark so and so had been intercepted. 2 persons were sitting in the vehicle. 3 jerrycans, 3 blue colored water jars containing liquid weighing 18.200 kg, 17.500 kg, and 17.200 kgs were recovered. they tested positive to codeine phosphate. As per drug detection kit, they tested positive to codeine phosphate. Samples were drawn from each bottle. He signed on the seizure list. PW's 6 and 7, 5 and 6 are independent witnesses.
No, 3 and 4.
3 and 4. PW 3 and 4 were independent witnesses. They admitted their signature on the seizure list, but could not identify the accused. They stated they signed the seizure list as per instruction of police. PW 6 was the officer in charge of the police station. He entrusted the investigation to PW 7. PW 7 took up the investigation. He prepared rough sketch map of index. He examined witnesses. He took steps for making inventory. He collected the inventory report. He proved the inventory report exhibit 12, which had been 11, which was countersigned by the magistrate. The photographs of the inventory as well as the compact disc of the inventory were exhibited as material exhibit 1 and material exhibit 2. He collected the chemical examiner's report and submitted charge sheet. Stop. The PW1, PW5 is the leader of the raiding party. His from his deposition, it appears he deposed. He received prior information exhibit 2 and communicated and forwarded the said prior information exhibit 2 with regard to transportation of narcotics. He forwarded the information to the superior officer and pursuant to permission proceeded to hold the raid. His deposition, the aforesaid evidence as well as his oral evidence as well as documentary evidence exhibit 2 unequivocally proves that the prior information was dispatched to the superior officer, and pursuant to his permission, the raid had been conducted. In light of the aforesaid fact, there is compliance of section 42 subsection 1 of the NDPS Act. Subsequent to the recovery, PW5 also deposed. Subsequent to the recovery, PW5 deposed. The intimation had been sent to the superior officer with regard to the said recovery in question. Accordingly, with regard to the said recovery, exhibit 8.
9.
Exhibit
8.
9 are the GDs. Exhibit 8. This complies with This is in compliance with section 42(2), read with 57 of NDPS Act. Without prejudice to the aforesaid, PW 7, the gazetted officer,
PW 8.
the gazetted officer was present at the time of recovery. Accordingly, the recovery was made under the auspices of a gazetted officer and under the auspices of a gazetted officer under section 41(2) of NDPS Act and 41(2) of NDPS Act and not 42. এইটা আগে দিয়ে from the evidence on record এইটা করে তারপরে বলো without prejudice to the aforesaid. Section compliance of section 42 of NDPS Act has also been satisfied. It has also been established, proof beyond doubt. হ্যাঁ বলে PW 5 এরটা করো, just reverse করে. Recovery being made, Mr. Chatterjee strenuously argues that the inventory and certification has not been made as per law. PW 7, the investigating officer prepared the inventory in place of the officer in charge of the police station. Good stuff. Officer in charge of the police station.
PW 6, officer in charge.
PW 6, 7. Officer in charge of the police. Section 52 capital A, inter alia provides section 52A, subsection 2 inter alia provides when narcotic drugs have been seized and forwarded to the officer in charge of the police station or to an officer empowered under the officer referred to in subsection one shall prepare an inventory of the said drugs. Subsection 1 of the said section, said provision, inter alia, lays down subsection 1 of section 52 capital A states the government shall by the government states in order to states having regard to this hazardous nature, vulnerability to theft, substitution, and constraint of storage space, etc. Storage space, etc. in respect of narcotic drugs, psychotropic substance, controlled substance conveyance, the government by notification in official gazette specify the drugs which shall be disposed of by such officer and in such manner as the said government may determine. Stop. nothing is placed on record to show that in the present case, the seizure had been reported. The seizure had been reported to the officer in charge concerned, officer in charge of Korimpur Police Station. Pursuant to his direction, PW7 had taken over investigation. Nothing is placed on record that PW7 was not empowered to investigate the case or exercise powers assigned to him, exercise powers under section 52 capital A, subsection 2 of NDPS Act. In such view of the matter, preparation of the inventory by the investigating officer PW7, who had been duly authorized by the officer investigating officer PW7, who had been entrusted to investigate by the officer in charge concerned, cannot be said to be illegal or without authority of law. Exhibit 11 shows that the certificate, Exhibit 11, as well as the material exhibits, namely photographs, Exhibit 11 bears the certification of the magistrate concerned, which has been admitted without objection. The documentary evidence is supplemented by the photographs as well as the electronic evidence, that is compact disc, with regard to the inventory. In light of the aforesaid clinching and unimpeachable evidence with regard to the certification preservation, with regard to inventorization, certificate preservation and inventorization and preservation, inventorization and certification of the seized consignment, failure to produce the Malkhana register cannot be a ground to come to a conclusion that there is a snap in the chain of custody. Chemical examiner's report, a chain of custody leading to the chemical examination of the samples. Chemical examiner's report, samples drawn from the said consignment. Chemical
Sample drawn from the spot was sent for
I
chemical.
know that was there. So, chemical examination of the samples. Full stop. No, of the samples. Of the samples. Full stop. However, though the samples had been drawn from the spot and not during inventory, there is no the authenticity of the sampling, neither the authenticity of the sampling of the samples had not been challenged in the course of trial. The authenticity of the sampling and sealing of the sample. Now, seals, chemical examiner's report also shows the seals of the samples were intact and matched with the seals sent to the chemical examiner. Accordingly, I am of the opinion the chain of custody of the samples concerned, a chain of custody of the samples drawn from the consignment is fully established, and chemical examiner's report shows the presence of codeine phosphate in samples, Exhibit 12. In light of the aforesaid discussion, I am of the opinion recovery of 53.4500 kgs of codeine phosphate from the vehicle which was occupied by the appellant and his co-accused
Seal and label. There is no seal and label as.
In the chemical examiner's report,
But also, if you also go through the FIR as well as the
does not
deposition.
require. See the chemical examiner's report. He
That-
sees the seal, he sees the label.
But
We do not require the seal and label in the FIR.
no, whether the seal and label was prepared.
The chemical examiner's report shows there is sealing. He doesn't say that open samples were sent to it.
Chemical.
Then- from no explanation. Co-accused has been proved beyond doubt. Appellant has failed to rebut. In light of the aforesaid, I am of the view possession of the appellant of the samples of the codeine phosphate, seized codeine phosphate is proved beyond reasonable doubt. He has failed to rebut the presumption under section 54 of the evidence of the NDPS Act, and the conviction against him has been rightly recorded. Appeal is dismissed. You had a case on the sampling. It was not drawn on the basis of the certificate. That is a defect that we have said that there is no cross-examination on that point, and the seal of the sample and the seal sent. The report, the chemical examiner's report doesn't say that the seals are tampered. So that is good.
Can there be
The FIR was against 4.
We know.
The charge sheet was against 2.
We know.
Still the other 2 kept on participating in the trial.
Then the charge has not been framed.
No, framed against only Safiqul.
Can there be any reduction of sentence? He was sentenced for 14 years. Can it be 10 years subject to correction by your lordship? Because independent witness subject to correction, lordship recorded everything, doesn't support the case. Maybe fault on the part of the defense lawyer during trial, because the sample, no question on the point of sample, whether sampling was done at the spot or not. That question was not put to the any of the witnesses.
Coming to the conviction or coming to the point of sentence, we note that the appellant, we note the prosecution case against the person, we note that the accused who were suspected being the consignee of the seized article were not put up for trial. Appellant does not have criminal antecedent. He appears to be a mere carrier accompanying the vehicle, which was used to transport the consignment. He is not even the owner of the said vehicle. In light of the aforesaid facts, we are of the view some concession may be made on the score of sentence. Sentence imposed on the appellant is modified and he is directed to serve rigorous imprisonment for 12 years and pay a fine of 1 lakh.
Can it be 10 years?
53 kg, sir.
Lordship, the weight is also because the prosecution case as per gazetted officer.
Chatterjee, there's a limit to stretch a case. All right. Just slicing down is good enough.
Grateful, Lordship.
Yes. Yes.
At 67.
Just hold on.
Under section 21C and 29 of NDPS Act, imprisonment,
We are
10-year imprisonment, 7 years, 7 months, I am in custody.
appellant is in custody for
600 grams of heroin.
not much. Appellant is what is the price of 600? Half of it is talcum powder. Appellant is in custody for about 8 years. Sentence is one of term imprisonment. Though appeal, paper book ready. Paper book is not ready, and appeal is not has not been prepared, and appeal is not ready for hearing. Under such circumstances, bail suspension of sentence on the ground of inordinate delay in disposal of case is not fettered by restriction on 37 of NDPS Act. In light of the aforesaid, we are inclined to suspend the sentence. Paper books, paper books be prepared within 4 months. 66.
67, I'm 67, man.
Both. Allowed.
Your lordship, Lord, appointed in this matter. Lord, in the meantime, there was a direction also, Lord, to communicate, Lord, to the appellant. It is that matter, Lord, where the lawyer has lawyer is in custody.
Oh, that matter.
That matter. So, Lord, one of the learned advocate, Lord, of this High Court, Mr. Hafiz Ali, he called me up and he said to give him the, Lord, the paper book.
Not this week.
I have given him, but
Not
still,
this week.
matter.
Not this week. Please inform Hafiz to be present.
My lord, I shall. তুই তোরটা করে দিস তো?
আমাকে তো বলেন ওটা ডিপার্টমেন্টকে ডাইরেকশন
এই রিপোর্টটা ঠিক আছে।
Well, 70, can I get a day's accommodation? Day's accommodation.
Not 72.
52A. Your lordship has kept it next week, my lord, the same order.
77.
So এই দুটো একসাথে হবে না? প্রথমে যেটা 80টা 60টা রাখলাম আর এইটা একসাথে হবে। এই 60 and 75 এর বান্ডিল দুটো না একসাথে করবে।
Only, my lord, apart from any day, apart
Not
from
next week, not this week.
next Tuesday.
Yes, next matter. 78.
But said by Miss Mandla, she is appearing on VC, your lordship.
Yes.
May please, my lords.
Yes, Miss Mandla.
Please, my lords. My lords, since your lordship had kept this for the appeal today, my lords. My lords,
May not be able to finish it today. We'll give you another date, but you commence the arguments.
please, my lords. My lords, your lordship, I have a small note prepared for your lordships to peruse.
But Mr. Orithro Bhattacharya is appearing on behalf of the
Orithro
state.
Bhattacharya.
Orithro Bhattacharya.
Orithro Bhattacharya. Okay. Yes,
My
fine.
lords, my lords, I have a small note prepared for your lordship's convenience, my lords. My learned colleague in court will just pass over the note to your lordships.
Sir.
My lords, the appellant, my lords, has been charged under and convicted under 302, my lords. My lords, already, my lords, he's undergone 8 years. My lords, the allegation of the prosecution is that, my lords, there were several dowry demands on behalf of the appellant, my lords, and the family members. However, my lords, the dowry demands have not been proved. That apart, my lords, the trial court's judgment, my lords, has heavily relied on, my lords, this one report, opinion report given by a certain doctor who was not even, my lords, the post-mortem doctor. And, my lords, even the IO says that I don't know, my lords, that how exactly this report even made it to the court. My lords, now with this, my lords, I'll just start taking your lordship to first, my lords, the complaint of, my lords, the de facto complainant, who's the father. He says on the day of the demise, my lords, of the deceased, that it could also be suicide. So, my lords, the suicide possibility has not been ruled out even in the complaint. Thereafter, my lords, in the post-mortem's report, if I may just take your lordship to the paper book, my lords. Your lordship may please have page 2, my lords, of the paper book.
Miss Mandla, you were charged under 304 capital B?
Yes, my lords. 304 capital B, my lords, was charged, and then, my lords, subsequently, my lords, the trial court says that, my lords, because 302 is a graver offense, hence we are giving you 302.
Since 20.
I apologize, my lord, I couldn't hear.
You are in custody 8 years.
8 years, my lords.
Yes.
Please, my lords, if I may just be permitted to show your lordship the complaint, my lords, and the post-mortem report for a moment, my lords.
So she was assaulted before her death and she committed suicide. How you convict under 302, Mr. Bhattacharya?
My lord, kindly for a moment seize PW 22, my lord.
PW?
22.
22 we are seeing. Come to page 63. From external injury, it could be said that it's simply a hanging case. It's a hanging case and we accept 227 external non-self-inflicted injuries. So in all probability, physical assault. Preceding a case of suicide. Torture, physical torture, therefore inferred. In-laws or the husband who were there failing to explain the injuries may be the authors of those torture. But they are not the cause of death. So your conviction under 302 becomes suspect, right?
304B, my lord, is
304B. Now we will come to 304B.
4B.
Whether there is a live link between the cruelty pursuant to demand of dowry and the unnatural death,
whether there
right?
was soon
But
before
admittedly, this is a case of suicide. Now, how many years after marriage incident occurred?
2 years, my lords. The marriage, my lords, occurred in December 2004, my lords. And my lords, this unfortunate accident, my lords, incident took place in 2006, my lords.
What is the accident?
Incident, my lords.
Ah,
Incident. I apologize, my lords.
unfortunate incident is 2 years. You made out a case for reduction of sentence.
Please, my lords. My lords, in fact, I wanted to fairly, my lords, say that, my lords, you may.
10 years. 10 years.
I bow down, my lords.
10 years.
I bow down, my lords.
All right. Well, today we can't keep it. Tomorrow we'll keep it. Huh?
Yes. Because, my lords, there's only one other argument, my lords. If your lordship may just permit me 2 minutes, I'll just show your lordship that on the dowry aspect as well.
Persuade us more. Again, we may change our mind to a graver.
I bow down, my lords.
You should be happy with 10 years.
My lords.
There is torture, physical injuries.
Please, my lords.
The saving grace is a suicidal death. So we won't put it to the maximum amount of life.
Please, my
and
lords.
bring it down. There is evidence of torture here.
Please, my
There
lords.
oral demand of dowry. And time frame is not that stretched.
No, my lords, in fact, we've gotten judgments for your lordships for 304B only, my lords. I bow down to my lords.
We have just we'll just go through the next tomorrow. Tomorrow we'll keep it, huh? Tomorrow just after 8. So no. Oh yes, anticipatory bill for order, specially. Thank you. Finished.
I bow down, my lords. I'm so grateful.
Exactly.
79 no, what is 7? All those are there.
79. Who's there? Now suppose evening course. Judges, then we can get judges. Judges are don't have retired judges.
एटीन की बार मतलब then 19 बार मतलब
Next.
83 to 85.
My lord. Very well, my lord. Tuesday. I'm deeply obliged.
86, 87.
नहीं, नहीं,